With regard to item number 11, consent to the my train. May play some little accommodation ballot. Any date
Please put on your speaker.
is there?
Yes.
Yes. No. Green will be better.
Yes.
Ah.
With regard to item number 11,
11, yes.
I pray for adjournment.
Prefer adjournment. Okay.
And after vacation, any day we are rushing. As your
Okay. Okay, the court master will give a date.
Man,
On the pair, both sides are duly represented. On the pair made by Mr. A.K. Hussain, counsel for the appellant. Matters is adjourned today. List on.
1611.
It is that matter. Your Lordship will remember. Lordship has called for the armor report at this
Ah,
the issue of revolt.
yes,
gun.
yes.
That report has come. The true copy has the certified copy has come.
Ah.
But in the same picture, overwriting is there.
Overriding is there.
Yes. In fact, Lordship, if original copy comes, perhaps that would make some
But it
difference.
doesn't change the nature. If it is if the certificate copy is true, then we take cognizance of that.
Yes, I've checked.
No,
It is.
it doesn't change the what you call
Overwriting is there from 0 to 6.
the status doesn't change. But but in fact, you see, we can't change the evidence right now. But what has happened is that despite whatever is there on record, the actual revolver which was issued to the person, that is not there again.
That is not there again. But as far as the appellant is concerned, that we can be sure whether it was at all issued to him. But then again, overwriting 0 is made 6 here. Trial judge has said it was 8, but we can make out it was 6. It is 6. So perhaps original copy
will
will
be for the proper attribution. Original will be, your Lordship kind enough to pass an order on 11, right? Asking true copy. So it will be perhaps better the original.
That's a true copy. What has come is a true
It is
copy.
already there before your Lordship.
What has come is a true copy.
True copy.
But we can't what you call create an evidence here in appeal.
Yes, we cannot.
No,
That
but
point was actually.
That's a limitation. If 8 is 6 or 6 is 8, whatever is there, we'll have to go by the trial court record. If we find a discrepancy, then maybe perhaps if at that point of time, if we think that it has to be remanded back for that purpose only, for finding of the evidence, because in the appellate court also, we have the power to direct the trial court to take evidence and then send the records back.
Yes.
So we can exercise that option.
That is 319 or 311, no, 319.
Huh?
That provision is perhaps 319 and
Whatever it is, there is a provision.
additional evidence.
Additional evidence in the appeal.
Yes.
That also we can direct. But that bit of time we'll think. Okay, 1611.
1611.
I'll just explain to my brother because he is not aware.
that point was gone into by the trial court and there was a long deliberation on that.
You see, I won't remember every details of it, but whatever I could remember, I just shared with my brother so that he is aware of what is happening.
Yes, yes.
That
At that point was gone into by the trial court, and whether trial court had called for the original register, I have forgotten. I
it
forgot.
was the original one, but it is compared with the original and kept.
Acha, huh. It was compared with the original.
It was compared with the original and kept. So therefore, the error which crept in the original register was there in the
Original
compared
register.
copy also.
Oh.
And again, same thing has happened in the copy which I have produced now.
Yes.
So
Oh.
status doesn't change. That's what I'm.
Then it will not make any changes. Lordship
That's
will
right.
hear it then on the materials. Lordship can switch on the microphone.
Yes.
11th of.
Hello.
Yes.
It is your lordship with regard to item number 7, my lord. Lord, I prefer an adjournment.
Okay. 7 yesterday it was one. Okay. Huh? But this is a tax matter with other matters.
Lord, I have informed item number consent of 8 applicant, my lord. I've taken consent of 8, my lord. The other matter,
Other appellants, you have taken consent.
8, my lord, and 6, my lord, I'll inform, my lord.
No. Information business doesn't work in this in these matters. When you're praying for adjournment, you should be very sure that you have taken consent. Otherwise, let the matter reach. I'm not adjourning.
I'm appearing for number 8. 8, my lord. is there.
It's okay, but 6 without consent, I'm not adjourning. You see, when there's a tag matter together, you should have taken consent of all the learned counsel. That is a practice I am not appreciating.
Yes, sir.
You had time for 2 days. Why for 2 days you could contact? So you wait for your time. Yes,
Lordship, I think to mention for listing the items, Lordship.
listing, give it to the court master. Here for listing, give it to the court master.
Yeah, my lord. Please, yeah.
You're there.
Lordship, for the appellate engaged counsel, Lordship, he's not well, so he couldn't even brief Mr. H.R. Sojri, who's engaged in this case. I was seeking
Okay.
adjournment.
On the joint prayer made by learned counsel for the appellant in all the connected appeals. The matter stands adjourned today. List after answering list for hearing after answering puja vacation.
I'll your list.
Lordship, I beg to mention item number 10, which I beg to mention item number 10. which
Number
may
10.
take- Yes, Your Lordship, which may taken after 2 weeks as my senior Arslan is out of station.
Okay, but it goes after vacation. We won't be able to adjust. List after answering puja vacation is paid for by learned counsel for the applicant. Okay.
List item number 1 for orders.
Back to the lordship. My lord, in this case, my lord, we have only done for the evidence of the case, my lord. I have, my lord, compiled the judgments, my lord. So I beg to furnish one of these.
Yes.
my lord, here, my lord, the first citation, my lord, 2020 12 SCC 630, my lord. I am referring, my lord, paragraph, my lord, 5 and 6, my lord, regarding, my lord, delay of FIR, my lord.
Yes. Oh, you've given notes also. Okay,
Yes,
that
my
is
lord.
good.
My lord, here, my lord, FIR, my lord, incident happened, my lord, 9 AM, my lord, and FIR, my lord, was lodged on the same day, 8:30 PM, my lord. But it is also, my lord, taken, my lord, on the facts and circumstances, my lord, fatal, my lord. So, my lord, I beg to read out the paragraph 5, my lord.
The
To-
incident occurred at what time?
My lord, it was happened 9 AM, my lord, on 30, my lord, 8 to 1991, my lord, and FIR was lodged on the same day. In the-
30.
Yes, my lord, 30, my lord, 8, 1991, and at, my lord, 9 AM, and FIR was lodged on the same day, 8:30 PM, my lord.
In our case, 15:10, 11 AM. Our case, 15th incident was of 15/10/2010 at 11 AM. And FIR was lodged on 19/10.
Here, my lord, more than, my lord, 12
No,
hours.
you are referring to the time given in the Supreme Court judgment.
Yes, my lord.
No. I'm referring to
Okay.
that.
Oh, my- sorry, my lord.
uh-huh.
In my case, my lord, it was, my
Okay.
lord, incident happened on 15, my lord,
11 AM.
11 AM, my lord, and FIR was lodged on 19, my lord.
Just one minute. What was the date? 15/10.
15/10,
2010.
2010.
At what time?
11 AM.
11.
And FIR on
19/10.
at. It will be in the form. Oh, that is after death.
Yes, my lord.
Yes, I recollect.
5.
It is, my lord, 19/10, my lord, 8:30 PM, my lord.
8:30 p.m.
Yes, my
Yes.
that too, my lord, FIR was lodged, my lord, by, my lord, their relative, my lord. Brother-in-law of the Alice, my lord, their disease, my lord. Not by the family member, my lord. So, my lord, I beg to, my lord, read out, my lord, paragraph 5, my lord, my running page in the paper book, my lord, page 3, my lord.
Yes.
To begin with, though the incident has taken place at 9 AM on 30/8/1991, and though the manner of all the 18 persons were known to the complainant, Kilan Singh, absolutely no valid reason was forthcoming on record as to why there was a delay in lodging the FIR. The accounts generally will not disbelieve the version of the eyewitness, even if there is some delay in lodging the FIR, if the version of the eyewitness are reliable and trustworthy. However, the delay needs to be explained. In this, the court in Apren Joseph versus State of Kerala emphasized that since a promptly filed FIR reflects reduced chances of embellishment, fabrication, or distortion in memory. In cases of delay in filing the FIR, it is important to assess the explanation thereof, to look for possible ulterior motives, and to assess its effect on the credibility of the prosecution version. The following observations of the court are pertinent in this regard. Now, first information report is a report relating to the commission of an offense given to the police and recorded by it under section 154 CRPC, as observed by the Privy Council in King Emperor versus Kawaj Nazir Ahmed. The received and according of the information report by the police is not a condition precedent to the setting in motion of a criminal investigation, nor does the statute provides that that information report can only be matter by an eyewitness. First information report under section 154 is not even considered a substantive piece of evidence. It can only be used to corroborate or contradict the informant's evidence in court. But this information, when recorded, is the basis of the case set up by the informant. It is very useful if recorded before there is time and opportunity to embellish or before the informant's memory fades. Undue unreasonable delay in lodging the FIR, therefore, inevitable gives rise to suspicion, which puts the court on guard to look for the possible motive and explanation for the delay and consider its effects on the trustworthiness or otherwise of the prosecution version. In our opinion, no duration of time in the abstract can be fixed as reasonable for giving information of a crime to the police. The question of reasonable time being a matter for determination by the court in each case. Mere delay in lodging the FI first information report with the police is therefore not necessary as a matter of law fatal to the prosecution. The effect of delay in doing so in the light of the plausibility of the explanation forthcoming for such delay accordingly must fall for consideration on all the facts and circumstances of a given case. From the observation quoted above, it is also evident that there is no hard and fast rule which can be applied to determine the effect of delay in filing the FIR, and the court is duty bound to determine whether the explanation afforded is plausible enough based on the given facts and circumstances of each case. A similar view was taken by this court in Ram Jog versus State of UP, wherein this court observed as follows. It is true that witness can not be called upon to explain every hour's delay, and a common sense view has to be taken in ascertaining whether the first information report was lodged after an undue delay, so as to afford enough scope for manipulating evidence. Whether the delay is so long as to throw a cloud of suspicion on the seats of the prosecution case must depend upon a variety of the facts which would vary from case to case. Even a long delay in filing report of an occurrence can be condoned if the witness on whose evidence the prosecution relies have no motive for implicating the accused. On the other hand, prompt filing of report is not a unmistakable guarantee of the truthness of the version of prosecution. So, my lord, my humble submission, my lord, maybe my lord, against this judgment, my lord. In our case, my lord, there is no explanation, my lord, and that in the FIR, delay FIR, my lord. Moreover, my lord, from the court also, my lord, there is no finding regarding, my lord, delay of the FIR, my lord. But here, my lord, Honorable Supreme Court, my lord, held that, my lord, it is the duty of the court, my lord, to give, my lord, deliberation regarding the delay of FIR. But here, my lord, more than, my lord, 12 hours delayed FIR in this case, my lord, in the Supreme Court case. But in my case, my lord, there is a, my lord, almost 5-day delay in the my lord, closing the FIR. Regarding, my lord, second citation, my lord, it is starting from, my lord, my running page in the paper, my lord, page 8, my lord, 2010 8 SCC 714, my lord. I beg to, my lord, refer, my lord, para 15, my lord. In a running paper book, my lord, page 14, my lord. May I read, my lord?
Yes.
Para 15, my lord. This court has consistently highlighted the reason, objects and means of prompt lodging of FIR. Delay in lodging FIR more often than not result in embellishment and exaggeration, which is a creature of an afterthought. A delayed report not only gets bereft of the advantage of the spontaneity, the danger of the introduction of a colored version, an exaggerated account of the incident, or a concocted story as a result of deliberation and consultation also creeps in, casting a serious doubt on its veracity. Thus, FIR is to be filed more promptly, and if there is any delay, the prosecution must furnish a satisfactory explanation for the same, for the reason that in case the substantum of the evidence given by the complainant information is found to be unreliable, the prosecution case to be rejected in its entirety. My lord, then my lord, regarding delay, my lord, I beg to refer another, my lord, judgment, my lord, my paper book, my lord, page 21. Here, my lord, this lordship earlier already, my lord, pointed out this is my lord, from the different background, my lord. Nevertheless, just my lord, I beg to my lord, refer this general observation in this regard, my lord, page 21. Page 21, my lord, paragraph, my lord, 8, my lord. Just I beg to my lord, your lordship earlier already said, my lord, this is regarding, my lord, the background is different. But I beg to my lord, just reiterate, my lord, just general observation of the Honorable Supreme Court, my lord. First part of the paragraph 8, my lord. There is no doubt that even there is only a sole eyewitness in a crime, a conviction may be recorded against the accused concerned, provided the court which hears such witness regards him as honest and truthful. But prudence requires that some corroboration should be sought from the other prosecution evidence in support of the testimony of the solitary witness, particularly where such witness also happens to be close related to the deceased and the accused are those against whom some motives or ill will is sought. Sorry, state, my lord. Here, my lord, only, my lord, one eyewitness, so-called eyewitness said, my lord, when getting information that, my lord, her husband was being, my lord, assaulted, she rushed to the, my lord, place of occurrence. Then, my lord, she had seen, my lord, accused person with arm, my lord, the lati, etc., my lord, coming from the place of occurrence, my lord. That much she said, my lord. But there is no corroboration, my lord. Then, my lord, I beg to, my lord, I am skipping serial number 4, my lord. This is not so much relevant, my lord. But citation serial number 5, my lord, 2010 5 SCC 645, my lord, starting from my paper book, my lord, page 36 onwards, my lord. Here, my lord, I beg to refer, my lord, paragraph 24, my lord. This is running page, my lord, 42. Paragraph 42, my lord, 24, running page 42, my lord. It is settled law on the point that FIR is not a substantive piece of evidence. However, the FIR can be given a complete by, since it can be used to corroborate the evidence of the person lodging the same. In the judgment of this court titled Baldev Singh versus State of Punjab, it was held that as far as the evidentiary value of FIR is concerned, it can only be used for corroboration of its maker, but the FIR can not be used as a substantial evidence or corroborating a statement of third party. Here, my lord, my lord, in this case, my lord, the informant, my lord, though lodged the FIR, my lord, after 5 days, my lord. But in the, my lord, FIR, my lord, he stated that, my lord, hand and, my lord, ear was chopped off, my lord. But in the no eyewitness or medical evidence said so, my lord. Therefore, my lord, and no, my lord, hand and, my lord, ears also recovered, my lord, during the investigation. It is also confirmed by the IO, my lord. So, my lord, the informants who is, my lord, PW1, his, my lord, evidence is not reliable, my lord. So, my lord, another, my lord, judgment, my lord, serial number 6 in my paper book, my lord, running page 48, my lord. It is 2024 SCC 33, my lord. Running page 48, my lord. Paragraph, my lord, running page, my lord, 54, it would be, my lord. Paragraph 1 to 11, 12, and 13, my lord.
Yes.
My lord, I beg to read out, my lord. Heard the learned counsel for the respective parties at length, we have gone through and considered in detail the entire evidence on record by the learned trial court as well as the High Court. We have also considered in detail the evidence on record, more particular the statement of PW8 Mullo by recorded under section 161 CRPC as well as her deposition before the court. At the outset, it is required to be noted that the appellant herein, original accused number 225, are convicted by the learned trial court and the High Court solely relying upon the evidence deposition of PW8 Mullo by it cannot be disputed that there can be a conviction relying upon the evidence deposition of the sole witness. However, at the same time, the evidence.
Just a moment.
May I proceed, my lord? Yes. 54 page, my lord, paragraph 12, my lord. At the outset, it is required to be noted that the appellant herein, original accused 2 to 5, are convicted by the learned trial court and the High Court solely relying upon the evidence deposition of PW8 Mullo. By it cannot be disputed that there can be a conviction relying upon the evidence deposition of sole witness. However, at the same time, the evidence deposition of the sole witness can be relied upon provided it is found to be trustworthy and reliable, and there are no material contradiction and or omission and or improvement in the case of the prosecution. Therefore, question which is posed for consideration of this court is whether in the facts and circumstances of the case can the appellant herein, original accused number 225 convicted relying upon the deposition of the sole witness PW8 and whether the PW8 is a reliable and trustworthy witness to convict the appellant herein original accused number 225. Having heard the learned counsel appearing on for the respective parties and considering the evidence on record, we are of the opinion that the evidence deposition of PW8 is full of material contradiction, omission, and improvements. My lord, I beg to submit, my lord. My lord, against this judgment, my lord, I beg to submit, my lord. Here, my lord, the main witness in this case, my lord, is my lord PW2, my lord, wife. But IO, my lord, it is confirmed that, my lord, what she did.
You have seen village life, you have stayed in village,
Yes, my lord.
you have experience in living in village.
Yes, my lord. My house
Correct.
is in Subar, my lord.
Is in
just
village.
near to our
Okay.
town, my lord.
Now tell me, in your experience living in a village, have you ever seen seen your village in pitch dark where you can't see anything? It may be Amavasya, it may be any other day. It may be a worst of the day with the thunderstorm when there is no light.
Yes, my lord.
But have you seen any day in your village when there is pitch dark where you can't see anything? Have you seen that experience?
My lord, I have, my lord.
You have,
Yes.
but I have never seen in my life a pitch dark where you can't make out anything. There will be some reflection of light from somewhere.
Yes.
Maybe it will be the reflection in the cloud. But what you call it? There may be some sort of darkness, but a pitch dark where you can't make out anything. That sort of pitch darkness I have never seen. So, Ms. Bhuya, you have seen a pitch dark where you can't make out anything.
I have not
So-
experienced.
I have not
that.
experienced
Much
that.
dark, my
No,
lord,
no,
I have
that,
also not experienced because, my lord, it is my place is not so, my lord.
That is what I'm saying. You
That
see,
that experience I have not. my lord.
you see, we are just considering, since we have placed the judgment, we are considering. We are not commenting on it, but we are just saying that. You come to Placitum G of para 13.1 you were reading,
Yes.
13.1, Placitum G. It says, third line, according to PW8, she identified the accused in light of the torch. There's no recovery of torch. So you see, the discarding of the evidence was not because the court considered at that point of time that a man is a villager. And in the village, people may recognize each other
Yes, my lord. Same here.
in the pitch darkness.
Yes,
Because in my house, I do switch off all the lights when I go to sleep. But even in the darkest of the hours, I can recognize people in the family who are moving
Yes,
in the
ma'am.
night, going to toilet or coming out for drinking water. But whatever the consequences or situation is, in the night also you can recognize by the
Yes, ma'am.
footstep also.
And some lights.
No, even
somehow,
by
somewhere.
footstep.
Yes, yes.
If my son is walking, from the footsteps he's taking, I can recognize that it's my son and nobody else.
Yes.
Because there's a drag in his
my lord.
in his footfall.
My lord, yes.
It's a drag. Normally we don't have that drag. So we can find out that it's
Yes,
the
yes,
son who is
yes.
going out, who is,
my lord. Exactly, my lord.
so these things are there
Yes,
in your own home, in your own locality.
Yes.
This, we are not commenting on
No,
this
no, no, no,
particular appreciation of evidence, but what I'm saying is that if the same situation, I put it in a different perspective, you may get a different picture altogether. That's what I'm trying to
Yes, my lord.
tell you. So therefore, that's why in every judgment they say that it will depend on the facts and circumstances of the
Exactly,
case.
my
Your
lord.
lordship,
But
and
this is,
in-
my lord, I think, my lord, this is general law, my lord.
Hmm.
Contradiction, my lord. Everybody knows, my
No,
lord.
we are not.
Yeah, yes,
we
my
are
lord.
not commenting on this, but
Yes,
where
madam.
I'm saying that we only change the perspective.
Yes.
Same picture, we are portraying it in a different
Yes, madam. Yes,
fashion.
madam.
It gives
Yes.
you a different. Yeah.
It is, my
You
lord.
see, two photographs, two paintings. In fact, one is in the Victoria Memorial, and one I have seen in Tipu Sultan's Palace in Hyderabad. Where you in Victoria Memorial, there's a painting of someone lying dead. I forgot who. He's lying dead, and there are soldiers and one High Lord who is standing there. At first blush, you only see the some people. Then you look at it again intently, then you find that it is actually they are mourning the death of someone. But in a first glance in that painting, you can't see everything. And you see it's fully lighted. But that's the art, that's the beauty of painting. And in Nizam's palace also, there's a painting where in the first blush, when you look at the painting, you won't see the entire picture. That's the beauty of those artists who have done that painting.
Yeah.
So even in a full light,
My lord.
there's a possibility that you will miss something if you don't look at it intently.
My lord, this is the, my lord, primary law of the criminal law, my lord. But my humble submission vis-a-vis the, my lord, impugned judgment, my lord. Your lordship kindly have noticed that in this case, my lord, so serious contradiction is there, my lord, regarding it. It is confirmed by the, my lord, the IO, my lord, that what she stated before the court, nothing was stated before him,
Correct,
before the
correct.
under. But
We
it
are
was
not discarding our argument.
No, no, no.
I'm just
and- yes, my lord.
we are just saying that perspectives may change because that's why on the facts,
Yes.
each case will have to be evaluated differently.
Lord.
That's the only point we are
Yes,
telling.
My lord, next judgment, my lord, I beg to refer, my lord, running page 56, it would be, my lord, 2012 3SCC, my lord, 56. Paragraph, my lord, 18. My lord, in this judgment, my lord, regarding, my lord, section, my lord, these are, my lord, convicted under section 149, my lord. So, my lord, Honorable Supreme Court, my lord, gave some deliberation under section 149, paragraph 18, my lord, running page in my paper book, page 63. That leave us with the question whether the commission of murder by a member of an unlawful assembly that does not have murder as its common object under the provision of section 149 IPC. Section 149 IPC reads, Section 149, every member of unlawful assembly guilty of offense committed in persecution of common object. If an offense is committed by any member of an unlawful assembly in persecution of the common object of that assembly or such as the member of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of the committing of that offense is a member of the same assembly is guilty of that offense. A plain reading of the above would show that provision is in two parts. The first part deals with case in which an offense is committed by any member of the assembly in prosecution of the common object of that assembly. The second part deals with cases where the commission of a given offense is not by itself the common object of the unlawful assembly, but member of such assembly knew that the same is likely to be committed in prosecution of the common object of the assembly. As noticed above, the commission of the offense of murder of Felicio Monteiro was itself not the common object of the unlawful assembly. In the case at hand, and yet the assembly was unlawful because from the evidence adduced at the trial, it is proved that the common object of the person comprising the assembly certainly was to either commit a mischief or criminal trespass or any other offense within the contemplation of the clause 3 of section 141 IPC, which may to the extent the same is relevant for the present be extracted at this stage. Unlawful assembly, an assembly of 5 or more persons in this designated an unlawful assembly if the common object of the person comprising that assembly is first, then second, and third to commit any mischief or criminal trespass or any other offense. From the evidence on record, we are inclined to hold that even when commission of murder was not the common object of the accused person, they certainly had come to spot with a view to overthrow and prevent the deceased by using criminal force from putting up the fence in question, that they actually slapped and boxed the witness, one of whom lost his 2 teeth and other sustained a fracture only proves that point. What then remains to be considered is whether the appellant as a member of the unlawful assembly knew that the murder of the deceased was also a likely event in persecution of the object of preventing him from putting up the fence. The answer to that question will depend upon the circumstances in which the incident had taken place and the conduct of the member of the unlawful assembly, including the weapons they carried or used on the spot. It was so stated by the court in Lalji versus State of UP in following words. Common object of the unlawful assembly can be gathered from the nature of the assembly armed used by them and the behavior of the assembly at or before scene of occurrence. It is an inference to be deduced from the facts and circumstances of each case. My lord, in the present case, my lord, nobody seen, my lord, the incident how it is occurred. Only, my lord, she said, my lord, she seen they are coming, my lord. Without giving, my lord, any deliberation, without, my lord, considering the, my lord, this 149 of the IPC, my lord. In the present case, my lord, 6 appellant, my lord, directly, without saying anything, my lord, they are held, my lord, they are accused of the, my lord, 149, my lord, and they are convicted, my lord, under 302, my lord. Then, my lord, I beg to defer, my lord, the judgment, my lord. This is, my lord, running page 164, my lord. It is very, my lord, latest judgment. I have no, my lord, SCC, my lord. So, but I relevant equivalent SCC number sorry, my lord, it is page 164, my lord. This Supreme Court judgment, my lord. Page 81, my lord. It's very recent judgment, my lord. I could not locate, my lord, in the SCC, my lord, just time. It is July 20, 2023 judgment. starting, my lord, page 81, my lord. I beg to, my lord, refer directly, my lord, page 227, my lord, in my paper book. 127. Para 34A, my lord. (34A), my lord, page running page 110, my lord. Married, my lord. On the other hand, the defense has successful in making a serious dent in the prosecution case for the following reasons. The first point is that one motive has not been set up by the prosecution as to why the appellant would assault the disease. All the witnesses of the fact who are family members have stated that there was no enmity between the appellant and the disease. Once there is no eyewitness of the incident, the prosecution will have to establish a motive for commission of the crime. Inasmuch as in a case of direct evidence, motive may not have a major role. If there is no motive set up or proved and there are direct eyewitness, motive may lose its importance. But in the present case, as admittedly no one has seen the occurrence, the motive has an important role to play. My lord, in the present case, my lord, here, my lord, nobody has alleged, my lord, there is any enmity, my lord. My lord, there is no eyewitness, my lord. Then why, my lord, these 6 appellants will kill him, my lord? So, as there is no eyewitness, my lord, they ought to have, my lord, alleged motive. Otherwise, my lord, why, my lord, person will simply kill, my lord? And accordingly, my lord, Supreme Court, my lord, in this case, acquitted the, my lord, accused, my lord. Motive is no proof, my lord. My lord, then, my lord, another judgment, my lord. (164), my lord.
One,
My lord, 117, my lord. Sorry, my lord. This is, my lord, 116, my lord. (116), my lord. Here, my lord, another, my lord, evidence, my lord, against the prosecution is that, my lord, medical witness, my lord, postmortem report, my lord. This is, my lord, Supreme Court held, my lord. In this case, appeal by special leave directed against the judgment passed by a single judge of the Gujarat High Court, summarily dismissing an appeal referred by the appellant against the order passed by the additional session judge number 11 Ahmedabad, convicting the appellant of the offence under section 376 of the Indian Penal Code and sentencing him to imprisonment for a period of 1 year. We think this is not a case which should have been summarily rejected by the learned single judge, and moreover, we do not think the learned judge was right in observing that our court have always taken the doctor as witness of truth. Even where a doctor has deposed in court, his evidence has got to be appreciated like the evidence of any other witness, and there is no irrebuttable presumption that a doctor is always a witness of truth. We would therefore allow the appeal, set aside the judgment of the single judge, and demand the appeal to the High Court. with a direction that the appeal may be admitted, and after issuing notice to the state, it may be disposed of on merits, my lord. So in this case, my lord, one, my lord, evidence which needs that to be, my lord, appreciated, my lord, postmortem, my lord, though he directly not there, my lord, because he already expired, my lord. But he, my lord, said, my lord, all the, my lord, injury, my lord, almost healed, like that, my lord. But one word he used, my lord, then there was a, my lord, some, my lord, blood clot he found, my lord. It is just his opinion, my lord. It may be correct or may not be correct, my lord. On the basis of his evidence, my lord, solely, my lord, they, my lord, may not be, my lord, judgment may not be correct. My lord. This is my humble submission, my lord. Then, my lord, another judgment, my lord.
It will be difficult in appeal to accept that your cross-examination to the doctor,
My lord.
the opinion expressed in the postmortem report was never questioned.
Question, my lord, it is apparently, my lord, contradictory, my lordship, because, my lord, this is a 302 case, my lord, and 6 person, my lord. But he said, my lord, all the, my lord, I will show, my lord, that, my lord, he said, my lord, almost all injuries are, my lord, healed. Nothing found that, my lord, it is not reaching. But once word he said that, my lord, there are some he found blood, perhaps, my lord, therefore he went to coma and ultimately he, my lord, expired, my lord.
Sure. So doesn't change anything.
My lord, this is a
Maybe healing of one of the injuries. You see, we have to show the nexus. A healing of an injury was not the cause of death.
my lord.
Cause of death was that 138 grams of blood which has been clotted in the intracranial region of the temporal areas
Yes,
of
my
the head.
This is their, my lord, his opinion. My lord. Needs to be, that is, my lord, needs to be considered by your lordship. Therefore, I am referring this judgment. That, my lord, the purpose of this judgment is that, my lord, your lordship is not bound to accept his, my lord, opinion directly, my lord. Your lordship may consider whether he was right or wrong, my lord, considering the attending factors or circumstances. Now, my lord, I beg to refer running page, my lord, 117, my lord. 117, my lord, this is 2020 12 SCC, my lord, 605, my lord. Paragraph, my lord, 43. 43, my lord, it is running page would be, my lord, in the paper book, my lord, 136, my lord, 136. May I read, my lord?
Yes.
43, my lord, para. In Abdul Syed versus State of Madhya Pradesh, this court discussed elaborately the case law on the subject of conflict between medical evidence and ocular evidence. Medical evidence versus ocular evidence. In Ramnarayan Singh versus State of Punjab, this court held that where there is evidence of witness for prosecution is totally inconsistent with the medical evidence or the evidence of the ballistic or evidence of ballistic expert, it amounts to a fundamental defects in the prosecution case, and unless reasonably explained, it is sufficient to discard the entire case. Then, my lord, the opinion given by a medical witness needs to be a last word on the subject. Such an opinion shall be tested by the court. If the opinion is bereft of logic or objectivity, the court is not obliged to go by that opinion. After all, opinion is what is formed in the mind of a person regarding a fact situation. If one doctor forms one opinion and another doctor forms a different opinion on the same facts, it is open to the judge to adopt the view which is more objective or probable. Similarly, if the opinion given by one doctor is not consistent with the probability, the court has no liability to go by that opinion merely because it is said by the doctor. Of course, due weight must be given to the opinion given by person who are expert in the particular subject. Drawing on this court has held that where the medical evidence is at variance with ocular evidence, it has to be noted that it would be erroneous to accord undue primacy to the hypothetical answer of the medical witness to exclude the eyewitness account, which had to be tested independently and not treated as the variable, keeping in medical evidence as the constant. Where the eyewitness accounts found credible and trustworthy, a medical opinion pointing to alternative possibility cannot be accepted as conclusive. The eyewitness account requires a careful independent assessment and evaluation for its credibility, which should not be adversely prejudiced or the basis is of any other evidence, including medical evidence, as the sole touchstone for the test of such credibility. Here, my lord, in my case, my lord, here, my lord, two evidence, my lord, medical. One, my lord, who first, my lord, gave first aid, my lord. Learned trial court, my lord, held that, my lord, that his, my lord, original medical record may not be available in the case record, my lord. But as a witness, my lord, credible witness, expert witness, he had seen some injury, my lord. But as per my lord, your lordship remember, my lord, as per postmortem report, totally different. What my lord, doctor of primary age, preliminary age said, my lord, injury found in the body, my lord, and what postmortem said, totally, my lord, day and night different, my lord. So it is, my lord, contradictory to the, my lord, first doctor who, my lord, give treatment to the, my lord, this disease, my lord, and other witnesses. And other witnesses also never, my lord, seen in this case that, my lord, we have seen such and such injury. Nobody said, my lord. And my lord, petition appellant before your lordship, my lord, assaulted by this way or that way, by this means or that means. Nobody said, my lord. Only, my lord, one medical witness said, my lord, I found some simple injury. But medical, my lord, doctor who postmortem conducted, my lord, he, my lord, as far as his report, my lord, there is some other injury. So there is contradictory, my lord. So in this regard, my lord, with all respect, my lord, balance would be go to the, my lord, other ocular evidence, my lord, and first doctor who, my lord, give treatment to the, my lord, disease, my lord. Then, my lord, in this case, my lord, one paragraph just I am just showing, my lord. Paragraph 141, my lord. Last paragraph, my lord, 60. What Supreme Court said, my lord. Independent of any facts, my lord, or allegation, my lord. Page 141, paragraph 60. In the criminal trial, the prosecution can succeed only if the guilt of the accused is brought home. That the accused may have done the crime barely suffices. The case of the prosecution as sought to be made out must be established. So learned trial court, my lord, totally, my lord, went to the surmise, my lord. They have done, my lord, committed crime, my lord. But criminal law says, my lord, what case they, my lord, projected, that needs to be proved, my lord, before the court of law. Then, my lord, citation, my lord, I am skipping, my lord, serial number 12 citation, which is not so much. I have already. Yeah. Then, my lord, serial number 13, my lord, regarding, my lord, circumstantial evidence, my lord, 154, my lord. (154), my lord. It is from live law, my lord, paragraph, my lord, 21. serial number, my lord, in my paper book running page 160, my lord, paragraph 21, my lord. My lord, may I read, my lord? Turning page 160, paragraph 21. A basic principle of circumstantial evidence is that in circumstantial evidence case, the prosecution is obliged to prove each circumstances beyond reasonable doubt, as well as the links between all circumstances. Such circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that we being all human probability the crime was committed by accused and none else. Further, the facts so proved should unerringly point towards guilt of the accused. The circumstantial evidence in order to sustain conviction must be complete and incapable of explanation of any other hypothesis than that of the guilt of the accused, and such evidence should not only be consistent with the guilt of the accused but should not be inconsistent with his innocence. These were so stated in Sharad B. So-and-so Supra, where the court, after quoting from so-and-so, observed that a close analysis of this decision would show that the following condition must be fulfilled before a case against an accused can be said to be fully established. The circumstance for which the conclusion of guilt is to be drawn should be fully established. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held in this court in so-and-so versus so-and-so, where the following observations were made so-and-so. Certainly, it is a primary principle that the accused must be and not merely may be guilty before a court can convict, and the mental distance between may be and must be is long and divides back conjectures from sure conclusion. The facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, they should not be explainable on any other hypothesis except the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved, and there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. These 5 golden principles, if we may say so, constitute the punch sheet of the proof of the case based on the circumstantial evidence. So, my lord, in this case, my lord, no circumstantial evidence was compared and considered, my lord, but directly, my lord, the punishment was inflicted, my lord. This is, my lord, dissent judgments. Sorry. Serial number, my lord, 14 judgment, my lord. It is starting, my lord, running page 164, my lord. It is, my lord, equivalent citation, my lord. I could not collect, my lord, but I have written the equivalent citation, my lord. It is 2021 13 SCC 716, my lord. I am just, my lord, one paragraph I beg to refer, my lord. It is, my lord, at page 227. It is general, my lord, law regarding, my lord, the benefit of doubt, my lord. Here in this case, my lord, 6 persons of the, my lord, family, my lord, were eliminated, my lord. But Supreme Court, my lord, gave the, my lord, benefit of doubt, my lord. Running page, my lord, 227, my lord. Paragraph 82, my lord. Yes. We may gainfully refer to the following observations of this court in the case of so and so, my lord. Paragraph 10 quoted, my lord. The burden lies on the prosecution to prove the allegations beyond all reasonable doubt. In contradistinction to the same, the accused has only to create a doubt about the prosecution case and the probability of its defense. An accused is not required to establish or prove his defense beyond all reasonable doubt, unlike the prosecution. If the accused takes a defense which is not improbable and appears likely, there is material in support of such defense, the cause is not required to prove anything further. The benefit of doubt must follow unless the prosecution is able to prove its case beyond all reasonable doubt. The facts that a defense may not have been taken by any accused under section 313 CRPC again cannot absolve the prosecution from proving its case beyond all reasonable doubt. If there are material which the prosecution is unable to answer, the weakness in the defense taken cannot be come to the strength of the prosecution to claim that in the circumstances it was not required to prove anything. So and so judgment. When the prosecution is not able to prove the case beyond reasonable doubt, it cannot take advantage of the facts that the accused have not been able to probabilize their defense. It is well settled that the prosecution must stand or fall on its own feet. It cannot draw support from the weakness of the case of the accused if it has not proved its case beyond reasonable doubt. So, my lord, in this case, my lord, honorable court, my lord, observed, my lord, regarding the benefit of doubt, my lord. Then, my lord, 19, my lord, serial number 15, my lord, running page 231, my lord. Paragraph 5, my lord. This, my lord, paragraph I have already, my lord, reiterated earlier occasion, my running page, my lord, 234, my lord. paragraph 5, my lord. The High Court, relying on the fractures of the ribs of the deceased as found by the doctor on internal examination, held that these injuries must have been inflicted by blunt weapon by other accused. We must at once note that, as already mentioned, there are no corresponding external injuries. These fractures could be due to violent fall also. The High Court further observed that the evidence of PW2, though hostile, can be relied upon, but PW2 did not speak anything about the occurrence. He deposed that he saw the 4 accused going away. When the evidence of PW1 is of doubtful nature regarding the participation of all the 4 accused, and when there is no other direct evidence, the evidence of PW2 cannot be of any use. No doubt, PW1 is the injured witness, and it is presence cannot be doubted. But unfortunately, his evidence is in conflict with the medical evidence, and the trial court felt that it is not safe to convict the accused on his sole testimony. In such a situation, and when the view taken by the trial court is not unreasonable, no interference in appeal against acquittal was called for. So, my lord, the 2 other judgments, my lord. Here, my lord, the page, my lord, the 236, my lord. Paragraph, my lord, 13, page, running page, my lord, 239, my lord. My lord, in this paragraph, my lord, running page 239.
Yes, paragraph.
Paragraph 13, my lord, 1-3-13. Running page, my lord, in the paper book 239. May I read, my lord?
Yes.
Yes, there also it was contended that this version of PW1 and PW2 regarding the injury of the disease being the result of 3 separate blows stood contradicted and falsified by the evidence of the medical officer, while not noting that there was a clear contradiction between medical testimony and the alleged eyewitness on his vital fact. The High Court brushed aside the evidence of PW10 in regard to these pivotal facts, with the convenient remarks that the opinion of the doctor on this aspect of the matter is merely an opinion and not a fact found by him. In the opinion of the High Court, the length of the injury, its wounds, and its extent would indicate that ordinarily such an injury may not be possible by one blow alone. With respect, we are unable to appreciate this approach adopted by the High Court. Dr. So-and-so was medical expert. He had performed the postmortem examination and noted that the nature and dimension of this wound. He has given clear, irrefutable reasons found on physical facts noted by him at the autopsy, which we have noticed earlier in this judgment, in support of his firm opinion that the only external injury found on the body of the deceased could not be the result of 2 simultaneous blows. In the ordinary course of human events and experience also, it was extremely improbable, if not altogether impossible, that 3 blows simultaneously given by 3 different persons from different directions with sharp edged weapon would land with such precise and accurate us so as to cause single wound of such clean cut margin and such dimensions and other characteristics as those of the external wound found by Dr. So-and-so PW1 on the year and the disease head of the disease, the version of PW1 and 2 with regard to this vital fact was inherently improbable and intrinsically incredible. It would not be accepted in preference to the evidence of the medical expert. My lord, my humble submission, my lord, against this paragraph is that, my lord. Here, my lord, the injury was proved, my lord. There was some injury, my lord. And my lord, the man was also died out of injury. This is good. But only because of, my lord, their contradiction, my lord. Accused were, my lord, acquitted. So, my lord, the contradiction always is, my lord, fatal. But learned, my lord, the single judge never, my lord, try to find out the contradiction of the case, my lord. And another aspect of this matter is that, my lord, I, my lord, so long, my lord, understood, my lord, perhaps, my lord, on the circumstantial evidence, my lord, they were, my lord, convicted, perhaps, my lord. But I have gone through the judgment, my lord, but they were, my lord, surprisingly, my lord, punished, my lord, for direct evidence of assault. Lordship kindly will look in the judgment, my lord, in the court's paper book, my lord, 117, my lord. (117) the paper book, my lord, under paragraph 20, my lord, 20 said, my lord, 20,
170.
my lord, 117 in the court's paper book, my lord. It is not my in my paper book, it's a court's paper book, my lord. I am, my lord, referring directly, my lord.
117 is the scissor list, part of
170
scissor
is the
list.
part of scissor list.
117, my lord. No, no. 117. Sorry, 107, my lord. It is like 0, like 1, my lord. 10, sorry, my lord, 107. Here, my lord, learned trial court under paragraph 20 says, my lord, thus their assemblage in such a manner comes within the ambit of unlawful assembly. Paragraph 20a, thus their assemblage in such a manner comes within the ambit of unlawful assembly as defined in section 141 of the Indian Penal Code, so and so. Since the accused person are armed with deadly weapons and committed rioting, there such act comes within the ambit of section 148 of IPC, and their offense under section 147 IPC would be merged therein. This is important, my lord. The evidence on record reveals that as a result of assault caused by the accused person, the victim Shafiqur Rahman, who initially assaulted, injuries subsequently expired of the injuries, and therefore the offense under section 325 149 will be merged under section 302. Only, my lord, this much finding. But where from, my lord, assault, my lord, the honorable learned trial court found, my lord, but no any witness, even there is any whisper that, my lord, we have seen assaulted. And, my lord, in this judgment, my lord, is not passed, my lord, considering any circumstance, my lord. As if, my lord, this judgment is passed, my lord, on, my lord, direct evidence. So, my lord, this finding, main finding under, my lord, 20C is, my lord, my humble understanding is that, my lord, it is perverse. Nobody, my lord, alleged any assault. And my lord, it is admitted, my lord, position of the prosecution case, my lord. No, my lord, medical treatment was given, my lord. It is, my lord, page 105, my lord, paragraph 18. It is, my lord, finding is, court's finding is also there, my lord, that medical treatment was not given. My lord, IO, my lord, confirmed the, my lord, the contradiction of the, my lord, PW2, my lord, who said that, my lord, there, she, yes, my lord.
That's all.
My lord.
Lordship, before I start, the other day, your lordship made a query whether government of Assam has any SOP as regards in place, my lord. I could try to, lordship, I could find one circular regarding comprehensive pro forma for inquest report, which was issued on 18 May 2023. Your lordship.
This is subsequent.
Yes,
This was recently because of. This has come up after our intervention.
yes, madam. Yes.
But at that point of time, there was no. Thank you for bringing me to notice of this. I was not aware, in fact, that this notification has come out.
Lordship,
We were informed that this would come out.
lordship.
Document itself we have not seen. Thank you for.
No, here you go, the soft copy.
Oh, this is still not final. Acha, it has been approved. But you have to uh, tell the authorities one more thing.
My lord.
It was approved. Political department. You see, there must be first a notice to all of them that if practicable, the inquest should be done at the place of occurrence.
Yes.
It's not there.
Yes. The chart, my lord.
There can be exception. Definitely, if an injured person is taken to hospital, then he dies at the hospital. So inquest there is permissible. But to remove a dead body from the place, taken it outside, the last matter which we were hearing,
Lordship.
there it has come out that it was late in the evening and therefore the police asked the dead body to be taken to the hospital, and therefore although the person had died in the place of occurrence, the dead body was removed. So
Lordship, here, the inquest report column, my lord, the place where, column 5, the place where the dead body was found, location,
no, that is, you see,
my lord.
if I am doing the inquest, the dead body is removed to the hospital. This para 5, I will write as officer doing the inquest. I'll write found in the hospital bed.
From the hospital.
Then you get the
I got
point
the-
we
your
are
lordship's
taking. You
query,
see,
yes,
if a person has died at the spot
yes,
on an attack, or whatever reason, he's been poisoned or he's been attacked, he died at the spot. So at that location, from that
Yes.
location, it should not be removed
yes,
first.
yes,
But there are certain exceptions. Supposing there's a road accident in the middle of the road,
yes,
there's a dead body. Now you can't close that road to have the inquest done. But then the photographs of the site, those has to be preserved, and then the body has to be removed.
Right.
So that's what we are saying.
lordship.
Yes. Hmm. Memory of the day. I mean, let's take Arindam if he's dead. If he's dead. Cannot be. लेकिन ये रास्ता है जेस रोड में मोटर एक्सीडेंट हुई है तब तो पूरी पता है कि वो मारे ये कोई भी नहीं है बस भी the person is dead.
Para 16 and 18, maybe read it. Column number 16 and 18.
No, you see, yesterday we were hearing that case of the girl. Throat was slit. Now, since it was evening, the magistrate said that you take her to the hospital. Now, a confirmed dead person whose throat was slit had been removed. So this para 16,
My lord.
nothing will be there. Correct. Now you see the difficulty is that supposing supposing you issue a circular, that's what the apprehension of my brother is also, that inquest is to be done at this spot. Then maybe tomorrow the police will not even take a about to die person to hospital. Because the first priority is the treatment to be given.
Yes, yes,
So you can't have a foolproof formula from the court
yes.
saying that this has to be done mandatorily. But what we are suggesting is that in this spot, people have seen that the person is dead. Then don't remove it. And if the person has some possibility of life being revived, then definitely first priority is to take him
Yes,
to
my
hospital
lord.
or her to hospital and have the treatment given. So it's not a hard and fast formula we are trying to prescribe. But what we are saying is that assuming that a person has been shot dead at the site, then please don't remove it from the site. But this will not apply again. This we have said in a busy GS road, there's a road traffic accident. And then the police says that no, we do inquest here and therefore the traffic is closed. That you can't do. You can't afford to do.
My lord.
But then there must be some SOPs to take care of those situations where the dead body is being removed. Then at least have the photographs for preserving this, filling up this paragraph 16, at what condition that dead body was found.
It may differ from case to case because in a natural human phenomenon, unless a
correct.
doctor confirms it, a person is dead, your lordship. General
No,
people,
I understand,
yes,
but there must be
yes.
some possibilities to
Yes,
take
yes,
care of
my
that
lord.
situation.
Yes, my lord.
Because you see, in a full public view, somebody has committed a suicide. Now, even because he's dead, you can't keep the body hanging in the public view. You have to remove it.
Yes.
So we are trying to say is that there must be some protocol for that
Yes,
also.
yes.
Because in a busy road, you can't keep a dead body hanging like that. It has to be removed. First priority to remove the dead body is to see that whether there is a life. For that also,
Yes.
you have to pull
First,
down the
yes.
rope and then have that.
Yes. Then your lordship, it might be a time consuming factor also.
No,
Because,
that's why
yes,
we're not saying,
treatment-
that's why we're not saying create a formula.
Yes,
We're saying that even for that,
yes,
people have to be trained.
my lord. Under what circumstances?
Under what
does-
circumstances,
yes,
what has to be done.
Yes, my
That is what we are
yes,
suggesting.
my-
Not a full formula. That if this is happening, you do this.
yes.
Not that.
Yeah.
That will be a judgmental decision of the police officer who is present at site investigating the
I
matter,
know.
or who has come for a preliminary inquiry. But he must know that he or she, the police officer who's taking a call at that point, they must know what to do.
Yes, your lordship.
At what point, either they should be trained, not with a circular, but they should be trained to deal with this situation. Because everything if you pen down, my brother is right, there can be misinterpretation of that.
Yes, my lord, yes.
Then they will say that, no, because the dead body, we want to remove it. But still, this is a good start, at least.
So I start with the instant case, your lordship.
Yes.
Uh, admittedly, there's a delay in lodging the FIR, so your lordship will just the delay is fatal or not for the prosecution case. Your lordship, may I take your lordship first to the first information report? Although the occurrence had taken place on 15/1, your lordship, 15/11, 15/10/2010 at 11 a.m. And there was two occurrences had taken place, in fact, my lord.
Why do you have to- is it anonymous? What is this? This is
Lordship, one on 15/10 and another is on 18/10. But admittedly, FIR was lodged on 18/10/2010, 19/10/2010. Lordship, first I take your lordship to the FIR, which is lodged by the informant Abdul Razak Chaudhary. He has been erased at the PW1, my lord. He's the landlord, my lord. And related to the victim also. Lordship, at page 8 is the FIR. I have the honor to state that around 10:11 a.m. on 15/10/2010, the above named accused person trespassed into our orchard situated at Dalidahar Grant and having tied the hands and legs of the caretaker of our orchard, Safikur Rahman, they first assaulted him severely. As a result, he became unconscious. Thereafter, they attempted to kill him using sharp weapon and cut one of his hands and one of his ears with dao. Informing Panchagram Police Outpost Barbeli, we took the injured person to Kalinagar Hospital from the place of occurrence with the help of one police personnel from the outpost. As his condition was critical, the doctors referred him to Silchar Medical College and Hospital. There he received 7 stitches. Be it mentioned here that around 10 a.m. yesterday, that is on 18/10/2010, taking the opportunity of our caretaker's illness, the above named accused person trespassed on our orchard again and cut and took away the betel leaves, betel nuts and bamboos. They also broke open the locked house of our caretaker and entering inside, stole the articles and occupied the house. The value of the household articles were around rupees so and so. The value of the betel nuts, betel leaves and bamboos were about 50,000 only. Now I take your lordship to the evidence of PW1. The informant, your lordship, at page 14. Has your lordship got it, my lord? Page 14,
yes.
the evidence of informant. I am the informant of the case. I know all the accused persons standing in the dock. My new house is situated towards south of Panchagram at a distance of around 3 kilometers at village Dholidhar Grant. My original residence is at Panchagram. I engaged one chowkidar, namely Safikur Rahman, to guard the said house and the landed properties at Dholidhar Grant. On 15/10/2010 at about 11 a.m. While I was at Panchagram in my original house, the son of Safikur Rahman informed me that the accused person Mujibur Rahman, Abdul Malik, Abdul Hannan, Sungul Ali, Rahman Ali, Samarun Nessa and Azmat Ali trespassed into my house at Dholidhar Grant and tied my chowkidar Safikur Rahman, assaulted him so brutally that his one hand ear had been chopped off and also inflicted blows by means of dao, lathi, etc. on his person. Then I immediately, along with the son of Safikur, went to the Panchagram PS and verbally informed about the incident. Thereafter, I, along with police, went to my said house and found Safikur lying on the ground in injured condition. There was profuse bleeding from his body. He was in unconscious state. Then we took him to Kalinagar PHE, but the doctor referred him to SMC Silchar. He received treatment for 3 days at SMC Silchar, but the doctors told us that there was no chance of recovery of the patient and asked his family members to take him back to the house, and accordingly he was discharged. On the next day, he died in his house in so and so. Lordship, in the this PW1 mentions why there is delay in lodging the FIR in his cross-examination at page 15. The distance between my house and the Panchagram PS is around half kilometer. I did not appoint Safikur Rahman with any written document as a chowkidar. I did not see the incident. Police did not ask for any document in respect of my land at Holidhar granted hence I did not produce it. In the FIR, I have not mentioned any description of the land. In the FIR, I did not mention the reason of 5 days delay. But since I was busy in providing treatment to the deceased, there was some delay. There are 5 persons in my family, including myself. It is not a fact that I have stated falsely that I, along with police, went to my house at Dholidhar and took the deceased at Kalinagar PHE. It is not a fact that I did not state before police that the son of Safikur informed me that the accused person assaulted Safikur in my house and chopped his ear and hand off. It is not a fact that I did not state before police that after getting the information, I verbally informed the same to Pancharam police, and along with police, I went to my house at Dholidhar where I saw Safikur Rahman lying on the ground in injured condition, and thereafter I along with police took him to Kalinagar PHE. There are both plain and tilla land in the village Dholidhar. It is not a fact that no treatment was provided to the deceased at Kalinagar PHE as well as SMC Silchar. It is not a fact that I have stated falsely that the accused person trespassed into my land and assaulted my chowkidar Safikur. Regarding the land at Dholidhar, there is no other litigation pending. After the incident, when police visited the place of occurrence for a purpose of investigation, I did not accompany the police. I cannot say what the police found during investigation. It is not a fact that there is no land of mine at village Dholidhar and no chowkidar was appointed by me, but with intent to harass the accused persons, I have filed a case with false allegations. It is not a fact that Safikur Rahman was not died due to any assault inflicted upon him by the accused person, and he died as a natural death. So in his deposition, he has stated regarding the lodging of FIR, there's delay in lodging the FIR, the grounds, my lord, for delay in lodging the FIR, and whether the accused person, victim was given treatment, and what the doctors have observed regarding the health condition of the deceased, my lord. Now I take your lordship to the evidence of PW2, my lord.
Just a moment.
My lord.
Just a moment.
Yes.
Your Lordship, may I now rely on the evidence of PW2, who is the wife of the victim, Your Lordship? Page 11. I know the accused persons, they are from my same village. I know the informant and he is my brother-in-law. About 9 years back, one day on Friday at about 11 a.m., my husband Safikur Rahman was in the house of the informant in his duty of chowkidari, and I was in my house. My house and the house of informant are intervened by 3 numbers of Tilla. At that time, 2 small boys came to my home and informed that the accused persons were assaulting my husband in the house of informant. I immediately started proceeding towards the place of occurrence, and when I reached the nearest tilla of the place of occurrence, from the top of the tilla, I saw the accused person, Abdul Malik Chaudhary, Sungul, Rehman Ali, Azmat Ali, Fatar Ali, and Samarun Nessa were returning back from the house of the informant, being armed with dao lathi. And when I started running towards the place of occurrence, on the way, the accused person Fatar and Malik assaulted me with a lathi. When I reached the house of the informant, I found my husband lying on the ground with injuries in unconscious state, and there was profuse bleeding from his body. Thereafter, police came and took my husband to Kalinagar Hospital and then to SMC Silchar. The doctor of SMC Silchar told us to take my husband to home and also directed us to provide the food whatever he likes, as he had no scope of recovery. After 4 days of the incident, my husband died. Police brought the dead body of my husband and post-mortem and inquest were conducted. There are houses of some people near the place of occurrence. I was informed by Jakir, my grandson, and Nurul Islam. I reached the place of occurrence. I saw the accused persons coming out from the place of occurrence being armed with dao, lathi, etc. The place of occurrence is the Tilla homestead land situated towards the north of village part. The house of accused person is situated to the east of the said Tilla. When I reached the place of occurrence, I did not find any other person amongst outsiders. During my presence, police person came at about 12:30 p.m. It is not a fact that I did not state before police that 2 small boys came to my home and informed that the accused persons were assaulting my husband in the house of the informant immediately. I started proceeding towards the place of occurrence, and when I reached the nearest tilla of the place of occurrence, from the top of the tilla, I saw the accused persons Abdul Malik, Sangul, Rehman, Ajmat Ali, Fatar, and Samarun Nessa were returning back from the house of informant, being armed with dao, lathi, etc. And when I started running towards the place of occurrence, on the way, the accused persons Fatar and Malik assaulted me with a lathi and have disposed of same falsely. With a lathi and have disposed of same falsely. I don't know, continuation, the sentences may not be correct. I have got 3 sons and 1 daughter. My husband has got 2 brothers and their offspring are still alive and near my house they also reside. I cannot say the dark number of the land of the informant in respect of which the incident occurred. It is not a fact that my husband was not appointed a chowkidar in the house of the informant, and the accused person never assaulted my husband and me. It is not a fact that the informant has got no land of village Solidar grant. It is not a fact that I have stated falsely that my husband was treated in Kalinagar Hospital and an SMC Silchar. It is not a fact that my husband died a natural death, but due to the previous grudge, the informant lodged a case falsely implicating the accused person. Here, this witness stands in the injured eyewitness, my lord. She saw the accused person running away from the place of occurrence, my lord, with dao and lathi in her hand, my lord. And she was also injured, my lord. Also, although there is no evidence to that effect, no doctor treating her was examined as a witness, your lordship. So may I submit, your lordship, her evidence is reliable, my lord. Next, I take your lordship to the evidence of PW3. This witness talks about the land dispute. So may I respectfully submit, your lordship, since there is a previous dispute as regards land, your lordship, the motive to assault and kill the accused, deceased was there, your lordship. Page 20, PW3. I know the informant of the
Just now, just-
lordship.
Now, if you have to believe this evidence of PW2,
My lord.
she says two small children told her.
Yes.
The
Those
identity
were-
of the two children are not known. She was assaulted. Her injury is not what you call, proved. Third thing, she says, if you believe her,
Now and nothing.
she says that the husband was taken to Kalinagar hospital and then to SMCH, where they told her to go home. But according to her, neither in the Kalinagar hospital nor at Silchar, the husband was given any treatment. She doesn't say about it.
Lordship, but regarding the other aspect, lordship, that the victim was advised to take home as his condition was not good, lordship, because there is no chance of recovery. So evidence of PW1 and PW2 corroborates to that effect, your lordship, regarding the condition, health condition. Regarding the treatment part, it's not there. Nothing is on record whether what treatment was given to the victim.
No,
But regarding the
no,
condition, my
no,
lord.
PW2 does not say about the condition.
No, she talks. She talks, my lord. May I?
He was lying on ground with
No,
injuries.
at page 18, my lord.
He was lying on ground with injuries.
No, regarding the doctor of SMC Silchar told us to take my husband to home and also directed
No,
us
first
to
line,
provide the
first line.
food.
First line,
Yes,
husband lying on the ground with injuries.
yes.
So nature of injuries is not said. So therefore, there's PW1 and 2, there is no corroboration.
No, regarding the health condition, that his health condition was not at all good, and there is no no use of giving treatment to him, as his condition is serious, my lord, and there is no chance of recovery. That aspect, it corroborates each other, my lord. PW1 and PW2,
Correct.
my lord.
What we are saying is that, number one, if you believe that, then in both the cases, the husband did not get any treatment. That is evident.
Right.
But then, if you go back to that postmortem report, you will find there is a description of one stitched wound of about 6 inches.
Lordship, the first part in the FIR, the informant has stated that he got injury on his ear. It was chopped off. So
No,
to that
no.
effect, injury report,
No, no,
postmortem,
that
and
is a
inquest.
incorrect English use. We have read the Bengali and we were smiling before we were rising up. In
We are
Bengali, it
reading
is
in
written
person.
কান কাটিয়া দিয়েছে আর then হাত কাটিয়া দিয়েছে.
Matlab,
So that
काटिया
is,
दिए छे
it's
मतलब
a cut injury. It's not
cut
a chopping
injury.
off.
Yeah, chopping off. Yes, my lord. So there.
No, English chopping off, you see, is severance.
Yes,
Chopping would indicate severance.
severance and
But this is not a case of severance.
no, your lordship.
It's a
So
case
to
of
that
cut.
effect, the injury report, the inquest report, and the postmortem report, lordship, tallies, your lordship. Probably tallies, my lord. Because may I take your lordship to the injury report? First
You
injury
see,
report.
In the inquest report, that injury is not shown. It
No,
comes in only
near your lordship. Lordship, check.
okay. Only 3 injuries are reflected in the inquest.
Inquest at page 113. my lord. Back office year, lordship pays 113.
Huh.
Second para, fifth line, marks of injuries are seen in the left side of his head and back of his ear. So your lordship,
No, that is injury. That's not
injury,
cut.
my lord,
That's not cut.
but it may be a cut injury, your lordship.
No, no. It can't be left to.
The
what you call-
specific word is not there.
It's not there. Mark of injuries are seen.
Yes,
Mark.
left side of his head and back of his ear, because inquest was done, your
Cut
lordship.
and injury.
Lordship, because the inquest was done on 2010, the injury which was taken place on 15, my lord, date of occurrence is 15. So mark would be there.
Okay.
When the injury reported pays 120, my lord. Postmortem is 120, your lordship. Lordship, injury report is pays 118. First doctor who treated the victim.
There is a, this
Multiple
is, this is
abrasion.
three. This is three what I was referring to.
Yes, of left
Multiple
ear.
abrasions. Multiple abrasions and tenderness.
Yes.
The cut injury is not there when the doctor first saw him.
So he is a homeopathic doctor, your lordship. There might be Ayurvedic. Ayurvedic.
Ayurvedic.
There
No.
might be.
It can lead to what you call conjectures. There has to be something very definite,
My lord.
because then you see here in the next page, come to page next page. It
This
says
120.
number 3 is dressing. Some dressing is done,
Yes.
but dressing and stitching are two different things.
Yes.
So
Why not?
somebody must have stitched it.
My lord.
Where is that evidence?
Nothing, my lord.
That's not there.
Lapses, serious lapses in the prosecution, my lord. Now I take your lordship postmortem report.
Yes.
My lord. In the postmortem report also, injuries were found on the vital part of the body head, my lord. It's near ear, your lordship. So may I submit the injuries stated by the, which has been described by the PW2 tallies with the injury report, postmortem report, as well as the inquest report, your lordship. And in the opinion of the doctor at page 125, your lordship. In my opinion, death was due to coma following massive extradural intracranial hemorrhage following grievous head injury caused by blunt weapon. So, your lordship, since accused persons were found carrying lathi and dao, your lordship. Lordship, it was the injury was caused by them out of that weapon, your lordship. Regarding the enmity part, my lord. Lordship, I'll be referring.
Just-
Yes, ma'am. Lordship, one more factor.
No, we have not been able to digest the first factor you have been submitting. Second factor will come next.
Lordship, regarding in the postmortem report, I'm trying, I think he
No,
is a
no.
good case.
No,
But I'll-
not
Yes.
that. We are not saying that. But you see, you must also know what brings smiles to us in this very case where there is a death. Why we should be smiling? The natural question. We'll answer that. Page 118.
Yes.
You there? Page 118, injury report number 2.
Yes.
Multiple abrasion on various sizes over right forearm, both interior and posterior aspect. Correct.
Yes.
Come to page 121. wounds, number 2.
Yes.
One stitched wound of so and so is seen in the middle of the back of the left forearm. But the hands are changed
Or left here.
right there.
Yes. My lord, original I have not checked. It's a type 1. Exhibit 4.
Left forearm.
It's written as right.
Hmm?
Injury report, my lord, exhibit 4.
No, is that postmortem report? Left is
No, I'm talking about the injury report.
left is correct.
Injury,
Injury
exhibit 4, my lord.
injury report is right. But it's a
Right,
photocopy.
right, yes.
It's a right. These are the two
So the
documents.
discrepancies, yes. Regarding the other factor, my lord, more descriptive, more
No,
detailed, my
there's
lord,
a question my brother will ask you.
my lord.
If we go through the exhibit 4,
Yes, my lord,
where there was only abrasion.
yes.
the
So where
doctor-
does the other injuries came?
Yes, when this, and in postmortem examination report, he found cut injuries with stitches. Then this cut injury must have been done after he was examined by the first doctor,
Yes.
because
So
it
I
was
s-
found,
Yes,
but there is no allegation that he, after he was examined, then he was again assaulted.
yes, no evidence to that effect, but there was evidence of two incidents of, which have taken place on 2 occasions, 15 and 18. my lord.
Second,
18th is something. which
Regarding
is-
robbery and whatever.
18th has
Yes,
come up only to
story.
explain the delay.
Yes,
You see, otherwise there was nothing. So therefore they have created a story that on 18th they came and they stole away this betel nuts and other things. So it is only to cover up for the delay.
Lordship, I should not submit standing on the side of prosecution. But it may be a case, well, it should not affect the case of the prosecution. Lordship, it might be a case because of the accused person again came and stolen away the valuables and whatever, fruit and whatever. That may be there might be an occurrence which had taken place out of that because he was the caretaker. So, Lordship, although the evidence hasn't come, it might be perpetrator, maybe someone else, my lord. I should
But
not
then you see,
submit, my
no, no,
lord.
not that, not that. You see, yeah. But then, you see that is the reason why we are, why Mr. Bobina is submitting that when there is no ocular evidence, then motive must be shown.
Yes,
So you see, on 15th when the assault took place, there was no motive.
yes,
It is on 18th that they came and they tried to steal this betel nuts and this
little leaves.
betel leaves and betel nuts.
Yes.
So the motive was not there when the attack took place. And on that day, there was no injury marks. That cut marks is not detected by the doctor
Yes.
treating him. And therefore, my brother is right in asking you that the cut marks which was seen must have has to be presumed because you did not recall and cross-examine or give evidence of the doctor who had given the first treatment.
My lord,
So therefore, that part of the evidence stays.
my lord.
This is a photocopy. Whether we take it or not, we don't know. But it's a photocopy, but that evidence has crept in the records.
Even the doctor has been examined.
It's okay. I
Yes.
missed out that.
My lord.
So therefore, that evidence is crept in. That there was no cut injury in the hand because the hand is not changed. So therefore, the second injury, even if you say that that was the second injury, that is not corroborated.
My lord.
Then the only issue remains on facts is that there was an assault in the left temporal region of the ear before above the ear. There not only abrasion is found, but it's a cranial bleeding. The intracranial bleeding is also found at that spot. So maybe whatever be the reason that has happened. Now again, two questions you'll have to answer. Number one, is it possible that on attack made by a stick, a cut injury may occur? That's number one. Number two, if thou is used for that assault, and there is a temporal, what you call, injury here, don't you feel that the nature of cut would have been more extensive? There's a cut of 6 inches in length,
My lord.
and that is impossible for the doctor, even if he's a Ayurvedic doctor, to miss it.
If there was, yes.
And that is in
injury
the
his-
hand. That is on the
bike.
hand.
Yeah,
That is
yes.
on the hand. And in
Yes.
the ear, if there is an injury,
My lord.
if a thou assault is made there,
My lord.
then there must be some more extensive injury apart from abrasion in the temporal region.
Serious
Yes.
omission, my lord.
Because
Should
we are trying to see, they have been convicted for 302.
My lord.
So for 302, the intention, there must be an intention of killing.
The motive part I submitted.
not that.
Yes,
Intention to kill is
Intention to
also
kill.
there.
yes.
You see the time lag. The children come, two children come running, cross over 3 tillas. From it's other evidence that they are 3 tilla away. So these two children, they are running and coming from 3 tilla, going to the house of the of this PW2
PW2.
to inform her about the assault. So therefore, these 6 people who are armed with weapon like sticks and dao,
My lord.
they had ample opportunity of murdering him,
Yes,
but they do not do it. They just assault him and come back.
my lord.
So intention to murder is never there. the prosecution must show the two things. Number one, the intention to kill, that is, mens rea must be present to kill there, and then there must be a motive. So both are absent. So
Motive,
cumulative-
I say, Mano, I should, I'm submitting, that there's a land dispute because the informant had purchased the land, dispute had occurred. It has come on record from the evidence of PW3, Mano.
There is an oral evidence.
Documentary evidence is not
The
there,
whole evidence is not there. So therefore, there to be a dispute,
Mano.
something has to be raised. First in point of time,
Mano.
to show that there was a dispute.
Nothing is on record, Mano.
Nothing is on record. So therefore, for there to be a land dispute, there must be number one, these people are Mohammedan by religion. The
Lordship.
purchaser is Mohammedan by religion. The people who could have objected, the assailants, they are also Mohammedan by religion. They have not invoked the doctrine of what is it called? Preemption.
Preemption.
That was never invoked. The period on which this sale took place, possession taking place, those are not on. These are not the
Yes, it
evidence
has
on
come
record.
up in the evidence, but not no documentary evidence. Oral evidence of from two, three witnesses, it has come up on record, but no document to that effect to substantiate that evidence.
No, you see, that's not what we are suggesting. What you see, number one, the date on which the purchase was made. The attack must be proximal to that. Supposing I purchase it on the 1st of January. Today we are on 21st of September. If the assault takes place now, you can't say it's a land dispute which has led to this injury.
Yes.
If it's a proximal time, I purchase it on 1st of September and today is the date of attack. Then you can show some proximity that
There should
yes,
be
people
close
came to know
proximity.
it was done secretly on 1st. People did not, the village did not know then. They came to know about it on 15th or 16th or 20th, and then 21st attack take place. And you see, the attack is not to take possession for the land. Second FIR says that they
Yes.
only steal Tamil.
Yes, Tamil Pan. In the first, on 15th, there is no allegation as such.
Means if there would be a land dispute, they would cut down the trees, they would demolish the houses.
Yes, madam.
Nothing of that sort.
Madam. Lordship, I have nothing to say because nothing is on record, madam.
No, we don't. We are not doing it. In fact, we are doing our job. We are satisfied so far as your legal stand is concerned. We are finding no fault in it. It's only the appreciation of the oral and the documentary evidence we are discussing. We are not commenting on your submissions.
See, gap is there, Lordship. What happened after 15? From 15 to 18, 19 is FIR. There might have another incident which has taken place on 18 due to that robbery.
No, 18. This person will not be there because if PW1 is to be believed, for 3 days he was getting treatment in hospital and he was busy giving him the treatment. So therefore, the owner takes upon himself that he was giving the treatment for 3 days. That means we have to exclude the deceased from the
Yes.
site of occurrence.
Yes. Yes, he was not there. He was with the in the residence of his son.
That is the second evidence of
Yes.
like that they took him home.
Yes.
So if the first evidence is to be believed, for 3 days this the deceased was in the hospital getting treatment, and he was being looked after by PW1.
Yes.
Now, PW2 introduces that he was taken back home and he was given whatever, what do you call this, in fact, no treatment at home.
My lord.
So evidence of PW1 goes. Both cannot stand together.
Lordship.
And the second is that you have to also submit a point which Mr. Babu was arguing, that to invoke 149 of unlawful assembly and making all of them liable, so that some act has to be attributed to one member of the member of the unlawful assembly. So nobody has seen them inside the
Assault
site of-
part is not there. They were found running, my lord.
But you see, then what is happening is that a vital. Let us see this police diary. Just a moment.
Who is Abdul Malik?
Abdul Malik. One of the accused.
My lord, sixth appellant, my lord, before that.
Okay, one of the accused. Please read this, Mr. Bhavia. Some tone of Bengali, I will miss it. Some tone of Bengali, I will miss it. That's why I'm passing it on to you.
আমার নাম ঠিকানা উপরের মতে সত্য আমার দোয়া অনুমান 50 বছর গত 15/10/2010 ইংরেজি শুক্রবার
No, we should hear it. It's a bit loud. We should hear it.
গত 15/10/2010 ইংরেজি শুক্রবার সকাল 10:11টা সময় 1 নম্বর জোড়া আলা তার ছেলে হান্নান সামসন
Just repeat that again loudly. Tar Lora.
গুড়াওয়ালা তার ছেলে হান্নান সামসন
Just a moment. Please give that name. That's important to us.
সামসুন
What is the name of the father?
গুড়াওয়ালা Gurawala, he is actually Mojibur man.
Huh?
Gurawala.
His son is
Actually accused number 1, my lord. My client
Okay.
instructed me, my lord. Accused number 1 and 2, my lord Hanan, they are, my lord, absconding the proceeding, my lord.
Okay. Okay, please proceed then. Please proceed.
Tasri Samson, Abdul
Abdul
Malik,
Malik,
Songul, Songul, Reza,
Rekman,
Rekman,
Rekman Ali,
Ali,
Azmat
Azmat Ali,
Qatar Ali, Aru, অনেকজন লোকে,
অনেকজন লোকে আমার স্বামীকে
সুপারি,
সুপারি বাগান গড়ের উঠানে আক্রমণ করিয়া লাঠি দা
বল্লম,
বল্লম
হাত দিয়া,
হাত দিয়া
আরো
মারপিট করিয়া জখম করে হান্নান
আল্লাহ শুনিয়া,
আল্লাহ শুনিয়া
মানুষজন
মানুষজন জমিলে বিবাদীগণ
পলাইয়া যায়।
পলাইয়া যায়।
আর প্রশ্ন পড়ো,
আমি
আমি
আমার
তাজিয়া না
ইয়া
ভতিজা
ভতিজা
জামাল উদ্দিন আৰু
জামান আৰু
অন্যান্য লোকে
অন্যান্য লোকে আমার
স্বামীক
স্বামী
জখমী
যখন
অবস্থায় চোরে
আপনি করে বান্ধি নিয়া গেলে
So you see, at that point of time, when the husband had died, then the affair was lodged. This investigation, the statement given by the wife is post death.
পোস্টে জখমী অবস্থা,
No, no. This was stated at a time when the husband had already died. After 18th.
আফটার 18 কোনটা রেখে দিছে 1910 1910
1910. So that is after death.
yes
So that time also it doesn't give the description of the injuries sustained by the husband. You see, this is not a case where immediately after the accident, it is reported to the police and the nature and description of the injuries which was required to be given was not given. It's a case where after death, the statement of injuries of assault is given on 15th.
yes lordship.
On 19th, that means the witness was
My lord.
examined on 19th. By that time, the husband had already died. But still, she does not give the description of the injuries which she saw on 15th on her husband, inflicted on her husband.
জখমী অবস্থা মানে she might not give the details. No, it's there.
No,
Yes, no, আছে কি তো নামটা আপনি জানেন yes madam
because if this evidence is to be believed, then she heard the halla.
Who is it? Jamaluddin Jumpel? ভতিজাক জন নেকি? আমি আমাৰ ভতিজা জামাল উদ্দিন আৰু অন্যান্য লোকে আমাৰ স্বামীক জখমী অৱস্থাৰ নিজাই থানাত জখমী কৰিলে পুলিচে চিকিৎসা কৰাই but she talks about two boys who
It's not
informed
there. That's what in the
the
cross
Jamal
examination.
no she probably may see no PW2
No,
oh Jakir and Nurul no not Jamal yes it's not there who has informed us
So therefore, we are just trying to reconstruct that incident.
I know
The wife who's residing 3 kila away, how did she know about that incident? It's not disclosed to the police. So in the evidence, when it comes that 2 boys came running and told us, that would be an improvement. A major contradiction then. Because the source of knowledge is not given.
last part of last part
We just go through the record, we'll take it up at 2 o'clock.
Right.
We'll take a break.
And my lord,
Because we are just trying to reconstruct what has happened from the evidence of PW1, PW2 you are reading. We're trying to reconstruct what has happened actually. And therefore there is a gap.
hello
So if there is a gap, then you have to accept what Mr. Babri is submitting.
লসে আমার স্বামী বর্তমান জখমী এটা কি লিখছে ঘরে জখমী অবস্থায় according to her 19 ঘৰে জখমী অৱস্থায় আছে।
মৰাৰ পিছত তোৰ যখন
নহয় নহয় এইটো ঘৰে জখমী অৱস্থা আছে
মৰি
লিখিছে।
গৈছিল ইয়াৰ আগত।
এইটো হয় কিন্তু লিখিছে আপোনাৰ ফেভাৰতে যায়।
And my lord, at first, my lord, she said to unknown boy told her, inform her. In cross, she said one of boy is my lord, her, my lord, their grandson. In cross first line, she said, my lord, grandson inform. In the first, my lord, the chief, my lord, she said, my lord, two boys. And my lord, two, my lord, it is, my lord, in the evidence of PW1, he stated that, my lord, son of my lord Shafiqur disease informed him that, my lord, by tiding, my lord, he is being, my lord, assaulted. But all evidence said, my lord, that he was, my lord, found, my lord,
We'll come to you. We'll
untied.
come back to you because otherwise, what do you call the direction? It will be a misdirection. So
He has concluded his part.
Yes, yes.
we'll hear her first because otherwise we'll be confused.
No, my lord. Paper book 17.
Lordship, in the case diary, I found the statement of the victim.
Gone by this.
Statement of the victim, it was recorded, Your Lordship. It was, but it was on 1910 at about 12:50.
Okay.
Or the victim, Sofikur Rahman. Then statement of Sofikur, injured Sofikur Rahman.
Sofikur Rahman, huh?
Yes, this statement is there.
Sure. What is that advertisement? Something with a twist? What is that?
something with a twist.
Something is being sold. They said something with a twist. The product. Huh?
Chocolate is it? No. No advertisement. Chips or the kid.
Huh?
Girl comes dancing from the gallery.
I don't remember. Just the catchword is twist. There's a statement in that advertisement referring to something with a twist.
KitKat নহয় নহয় ঠিক আছে এটা তো খুব চিপস এটা তো খুব হেৰি কৰে কুৰকুৰে কুৰকুৰে নে কিবা কৰে
Kurkure is something like a twist.
এই সাইড খান জি আঞ্জলি যে
Huh? So this case is also turning out something like that. Straight line with a twist. You've done a good job to find out this at least.
Lordship.
You've done a good job to find out this at least.
Chevy investigation.
Huh?
It's a case of Chevy investigation.
No, we are not jumping into a conclusion. There are many things which is coming to our notice. It's just that we have not been able to pigeonhole everything we are looking at. There are some missing gaps.
Yes, my lord.
Now, this is the statement. correct?
Yes.
Turn the page. This is the CD, correct?
Yes, yes.
Now you find the entry there at 10 a.m. on 1910.
1910.
1910. No, the first, your hand was there. 1910, first,
Yes, 1910.
correct. Now,
Date
two,
of DA, I don't know, DA, what is the D?
no, whatever be,
Yes, yes.
DT, I think,
DT,
date.
date, yes,
Huh.
date.
Now turn 2 or 3 pages. In the top, you will find house of the deceased. Then take turn next page. First left hand, no, the right page. Huh? In the top, you will find house of the deceased.
Yes, house of the deceased, arrival note, holding inquest.
So that is 10 a.m.
It is 10 a.m. on 1910 and on 10
Has to be
a.m. on
1910 because there is no other date.
10 a.m. 1910, yes.
1910.
Yes.
Now come to the evidence of PW1
PW1.
at page 15 of the paper book.
Yes, madam.
Third line, on the next day, he died in his house on 2010 at 5 p.m.
Third line at page 15. On the next day, he died at 5 p.m. So,
But 10 o'clock, the
yes,
police was already there.
yes. Yes, your lordship. And lordship, prior to the statement of this one, the injured, there's entries there.
So that entry we found.
Yes.
That is on 1910 entry is at in the morning 8:30 a.m.
Lordship. No, injured was taken, something is there.
He was medically examined.
Yes.
On the first page only. First or second page. No, don't go beyond that. Last line, last part of the.
Somewhere I found your lordship.
I'll show it to you.
Yes.
Pass it on. I'll
Right.
show it to you. It is when the case diary is starting.
Yes.
The first or second page you will find at the bottom. But this is a language I'm not. I can't read it properly.
You can gently open. Somewhere on the left, I found it. My
Yes, yes. No, you have come to Caesar.
prior to that.
— 8:30. Signature. থাকে যে Not here. Wait. Injured transfer has already been medically examined by the customer PSC. Time 8:40 AM. This the printed page 31 there. Yes, in the middle. Yes, where your hand is.
Yes.
So and so has been medically examined.
On receiver for so assault of so and so, injured so and so has already been
So this is
medically
8:40.
examined.
8:40 in the morning
8:40,
or 1910.
8:40 p.m. But there was one more, I found it somewhere. One more.
No, just check up because I have
Yes,
you've
I
only
found
seen
it.
2 or 3 pages which you have forwarded. This is a handwriting I can't read properly. That's my difficulty now.
Now, person, injured person, assigned following.
So do you see?
Lordship at 12:50 on,
19.
it would be 19.
Everything is 19.
Yes, my lord. It would be on 1910.
Ah.
Now, so and so at the house of injured person, examine following injured person recorded statement. It is at 12:50 p.m.
12:15.
House of the injured, yes. Yes, 12:50 p.m.
12:50 p.m. So he died on 1910 about 5 p.m.
Yes.
Just try to read both of you together that statement
Of the injured.
of the injured.
আমার নাম শফিকুর রহমান চৌধুরী, আমার বয়স অনুমান 60 বছর। গত শুক্রবারে আমি আমার এইটো কি? উঠানে মানে কি? উঠানে ছিলাম। সুপারি ও পানের 11 ঠিক সময় মুজিবুর রহমান তার স্ত্রী শামসুন নেসা তার সোয়েনসো হান্নান আব্দুল আর দেখে যে তার সালা আর অন্যান্য কুটুম সুপারি বাগানে যায়। আমি আমার উঠানে ছিলাম। আমার তখন হান্নানে প্রথমে Mula Asia কালোর লাঠি দিয়া আমার জখম মাথায় কি বাম দিকে
হ্যাঁ, মাথা বাম দিকে, হ্যাঁ।
on the left
হ্যাঁ,
side
left side।
আঘাত করে
হুম।
আমি মাটিতে পড়িয়া যায় এবং চিৎকার করি তখন মুজিবুর তার সালা ফাটার আজমত আলী এজনকে রেকমান সবাই এটা কি ওর দিয়া হাত দিয়া আমাকে শরীরে
জখম।
জখম করে
হুম।
মাটিতে জখম করে আমি পড়িয়া যায় নাকি এটা অজ্ঞান পড়িয়া যায় তাই আমার জমির নাকি মানুষে
অজ্ঞান হয়ে যায়,
আমাকে
vaccination হতে হবে।
বাড়ির মানুষে আমাকে আনে আমার শরীরে বাহির ভিতরে জখম হয়েছে ডাক্তার ডাক্তার চিকিৎসা করেছে বর্তমানে আমি আমি লড়াচড়া করতে পারি না that much
He became immobile at that point of time.
1910
Difficult to speak.
Lordship, if your lordship considers the postmortem report, I'll take your lordship. Page number 125. The rupture of the left middle meningeal artery resulted in gradual and constant hemorrhage, which caused a massive extradural hemorrhage in 138 grams. So gradually, maybe his condition deteriorated because of the injuries received by him. But in
But
between, there's a
still-
missing link.
At my thou, etc. is not here also mentioned.
They should have
But
exhibited
even
it,
then,
my
my
lord.
lord,
To be dying declaration should have, my lord.
That's the defect in the prosecution which were done. You cannot help it now. Because even that statement, he is right.
My lord.
Attack by thou is not there.
and that apart, my lord, with all respect, my lord, whether, my lord, this kind of statement, my lord, nowhere in the evidence came out, my lord, and proved, my
That's
lord.
a lapse of the prosecution. It has to be
Yes, my lord.
pointed out.
And in the, my lord, I did not refer already in my paper book.
We will
there-
come to you, otherwise we'll be confused. We are following a track.
Yes, my lord, yes.
Go to commission, lord. Go to commission, lord.
Was the IO then?
Lordship, Ayo,
Was the IO then? Some Rajbongshi then. Some Rajbongshi. my lord.
1910. Subhash Chandra Das, এটা নহয় PWT 10 to
PK Rajbongshi. my lord. PK Rajbongshi. Yes.
কোথায় এটা?
Okay, you complete your part.
Lordship.
You complete your part.
Regarding lordship, whether the accused person can be brought in under provision of 149, my lord, IPC. May I cite one decision? How's it 23, my lord? But-
Just remind me of the time that the statement of the victim was recorded at what time? 12:40.
12:40 PM. Twelve
50.
yes.
And this, the entry of the date of visit at the house of the deceased, what is that time given? I
That
flagged
is
that.
12:50.
No.
Now.
No. I have flagged that
Oh,
for
shit.
part,
Yes.
that, what do you call it?
Time.
No, it will
Not
be in the
this
left,
one.
left side flag, huh? Yes.
This is a statement. Not this.
No, that the page I showed you in the top, it is written house of the deceased.
Yes, somewhere I found.
It will be 4-5 pages after 19 entry, huh? Yes, almost here. No, not, it was in the right side page.
Yes. This is 12:20, house of the deceased, house of the. Oh, this is house of the accused maybe.
No, then next page, there will be a entry house of the deceased. No, not left side page, right side page. No, not on your left hand page. Right hand
Page, I'm
page.
not finding it, my handwriting is so, I can't read it.
Just pass it on. Pass it
I'll
on.
pass it on.
House of deceased at 10 a.m. House of the deceased, that is 10 a.m.
No, yes,
Entry is 10 a.m.
my lord.
But then it doesn't match.
Yes, my lord.
Statement is recorded at 12:50.
Oh, no, it's a house of the deceased, my lord. 10 PM, maybe 10 PM.
You see next page also, entries are, it appears AM, it doesn't appear because it's PM. Yes, that page only. There are
Here no
entries.
entry, here no entry. 10:30. Lordship can't make out whether it's a AM or PM ban because it is written as deceased. By the time he expired, that means.
No, you see the entry when that statement is given, same AM is written. It doesn't appear to be PM.
PM. অপরাহ্ন এগুলো লেখা নেই। 10 AM, then 12:50. Lordship, 10 AM and 12:50 PM maybe. 10 AM they have,
No, you see the difficulty is, we all know what happens in a police station.
yes,
He
I
goes
know.
to the IO goes to the site. He does not carry CD with him, and therefore he sees everything, comes back, and then he records.
My lord.
But he forgets that the statement is being recorded at 12:50 PM, and since by then after that he died, so he's writing in the case diary. Seen gone to the house of the deceased. He went there when he was alive. You get my point?
I understand.
He should have written there, went to the house of the injured. But since he writes the case diary after he died, it was a back entry, backdated entry. Therefore, he writes, went to the house of the deceased,
Yes, my lord.
and that spoils everything.
10 AM, 12 PM. If 12:50 PM the statement was recorded, that 10 AM she would not have been died.
House of
your
the
lordship.
deceased. No,
Yes,
no,
my
no.
lord.
His writing
He
is
should-
okay, but his writing is wrong because of the fact that he's
Injured and deceased, my lord.
injured and diseased. He does not
Yes.
know. When he
My
goes
lord.
back to the Thana, when he writes, he has seen the man dead. So he writes in the case that he went to the house of the deceased. He might have done everything correctly.
My lord.
He went to the house of the victim,
Yes, my lord.
but by the time he died, and therefore when he comes, he writes house of the deceased. Because we also face the same difficulty in writing the judgment in criminal matters. You see what is happening. The IO came and recorded the statement of the victim. I can't write in the order. IO went there and wrote the statement of the deceased. So then we realized that we made a typing error or writing error. Because you see, we are at the appellate stage, we are looking at the case of the deceased.
Yes, my lord.
So deceased is in the mind.
My lord.
So when we are writing, we have to be very cautious in writing whether the statement of the deceased was taken or the victim was taken. That is a mistake, common mistake. In fact, when I am writing a judgment, I make that mistake. That so and so recorded the statement of the victim or statement of the deceased. That deceased word comes in.
My lord.
The same thing has happened here.
Two citations and referring.
That was 10 AM.
Yes.
Okay. Okay.
2023 minutes. 5 SCC 391.
20.
2023 5 SCC 391.
3.
91. So constitutional bench judgment of Honorable Supreme Court, madam. Rava Sahib alias Rava Sahib Gowda and others of the state of Karnataka. It's on the point of delay as well as on the point of applicability of section 149. madam.
Yes.
Lordship, para 27, 20, and 40 as regards delay in filing the FIR and sending to the magistrate, your Lordship.
27.
27, delay in sending FIR. Here, delay in lodging the FIR, Lordship. Unless serious prejudice is caused, mere delay in sending the FIR to the magistrate would not by itself have a
No,
negative
no, no,
effect.
that's not the,
That's not the issue here.
That's not the issue. here.
But delay in lodging the FIR, whether it's Lordship, fatal to the prosecution case. And regarding the other part, your Lordship, section 149, para 30 to 32, your Lordship.
How does it start, paragraph?
Para 30, my lord.
How does it start?
A
Starting
three
like
judge bench of which one of us so and so was a member observed as under in respect application of section
Just, just,
149.
just.
Has your Lordship got it, my lord?
No, just give me.
Cases involving several accused persons.
Just. When a case involves large number of assailants,
No, your Lordship, a three judge bench of which one of us, B.R. Gavai J, was a member observed as under. Has your Lordship got it?
yes,
Yes. A three judge bench of which one of us, B.R. so and so, was a member observed as under in respect of the application of section 149 of the Penal Code 1860. Section 149 of the Penal Code 1860 is declaratory of the vicarious liability of the members of an unlawful assembly for acts done in prosecution of the common object of the assembly, or for such offenses as the members of the unlawful assembly knew would be committed in prosecution of that object. If an unlawful assembly is formed with the common object of committing an offense, and if that offense is committed in prosecution of the object
30. No, please continue.
by any member of the unlawful assembly, all the members of the assembly will be vicariously liable for that offense, even if one or more, but not all, committed the offense. Again, if an offense is committed by a member of an unlawful assembly, and that offense is one which the members of an unlawful assembly knew to be likely to be committed in prosecution of the common object, every member who had that knowledge will be guilty of the offense so committed. While overt act and active participation may indicate common intention or the person perpetrating the crime, the mere presence in the unlawful assembly may fasten vicarious criminal liability under section 149. When a case involves large number of assailants, it is not possible for the witness to describe the part played therein by each of such person. It is necessary for the prosecution to prove each of the members of the involvement, especially regarding which or what act. The Masalti case has been observed. The Court of Appeal, this much only I'm relying on, your lordship. There may not be any specific overtake on the part of the accused person to attract the provision under section 149. And one of the factor, your lordship will kindly observe, kindly note, your lordship, the occurrence had taken place in the residence of the informant, my lord, wherein the victim was the deceased was the caretaker, your lordship.
No, incidentally, that was not a place of residence. It was only
No,
a,
it was whatever
it
maybe
was a
it
garden.
belonged to the informant.
Huh.
It belonged to the prosecution side. It's not a case that the prosecution side went into the land or whatever, your lordship, to a place wherein the accused persons were in occupation. It's not a case of the prosecution, my lord. The occurrence had taken place in the land which belonged to the informant and wherein the victim was the caretaker, my lord.
okay.
Lordship, one more
Just-
citation, 2022.
Just.
Right. Time over. Lordship, in that judgment, I'll be referring one more paragraph, para 45. And 46. The paragraph starts, my lord, we have also noticed the holding in the landmark Masalti.
40.
45 here in SCC, Your Lordship.
We have one.
We have also noticed a holding in the landmark Masalti, where 4 learned judges have held that the prosecution did not prove specific acts to specific persons. With neither the number nor the presence of the accused being disputed, we cannot within law hold that the accused have been wrongly convicted by the courts below. Here, one of the accused persons have taken the plea, he was not there, but others have not taken the plea. Lordship, para 46. PW1 is an interested witness, although he has not taken the plea, Lordship, because the here PW2 being the wife, he has not taken the plea, but I'm making the submission. PW1 is an interested witness being the brother of the deceased, as also he being the solitary witness upon which reliance is placed by the learned trial court is put forward as a ground before us to question the verdicts. The position of law as held in Harbanskar versus State of Haryana is clear in stating that there is no proposition of law which doubts the statement of a close relative simply for that reason. There is a note of caution sounded in Bhaskar versus State of Maharashtra, which is undoubtedly on point, but we may also note the observation of this court in Rajesh versus State of UP, wherein it has been observed. Once again, we reiterate with a word of caution. The trial court is the best court, Your Lordship will kindly note. The trial court is the best court to decide on the aforesaid aspect, as no mathematical calculation or straitjacket formula can be made on the assessment of a witness, and the journey towards the truth can be seen better through the eyes of the trial judge. In fact, this is the real objective behind the enactment itself, which extends the maximum discretion to the court. Then one more judgment, my lord, 2022. 6 SCC 508.
In the earlier judgment, you are relying on paragraph 42.
Then, sorry, 40, then
Lordship. 30 to 32, Your Lordship. Then
30 to 32.
and thereafter, Your Lordship. Para 45 and 46.
Yes. Okay.
The need judgment. 2022. 6 SCC 508.
Now you're setting 2022.
6 SCC 508. State of UP versus Subhash LS Pappu.
Twenty 6 SCC 508.
My lord.
Para
Para 5.6.
5.6.
My lord, 5.6. 6.2, I'll read out, Your Lordship. Para 5.6. Ms. Garima Prasad, learned senior advocate appearing on behalf of the state, has next submitted that the High Court is materially erred in acquitting the respondent accused on the contradictions in the FIR complaint given by PW5 that the respondent Subhash Elias Pappu inflicted a knife blow and that in the dying declaration, the deceased has stated that Pappu, son of so-and-so, hit him by a hockey stick. It is submitted that once at PW5, the informant was declared hostile, nothing mentioned in the FIR complaint should have been considered. That as a result, the only evidence which was available was the dying declaration in which it was specifically stated that Pappu hit him by a hockey stick. It is submitted that therefore being a part of the unlawful assembly and some person inflicted a knife blow in the stomach of the deceased who died due to the injury by knife blow, still the respondent accused can be convicted for the offense under section 302, read with 149. As well as section 140 IPC. It is submitted that as such, the trial court rightly convicted the accused for the offenses under section 302 and 148, relying upon the dying declaration dated 5/12/1980. It is submitted that in the impugned judgment, the order of the High Court has not as such doubted the credibility of the dying declaration recorded by the Eastern Divisional Transport Officer. It is submitted that therefore, there can be a conviction based on a dying declaration, which has been established and proved by the prosecution. Then para 6.2, my lord. It is further contended by the learned counsel appearing on behalf of the accused that even in the dying declaration, nothing was mentioned as to who in fact inflicted the knife blow. That on the contrary, it is specifically stated in the dying declaration that Pappu hit by a hockey. Therefore, in absence of any specific allegation against the accused inflicting the knife blow, and the accused was not charged for the offense under so and so, the accused can be convicted for the offense under 302 with the aid of section 149. Then para 6.5, my lord. And regarding the Caesar is there, your lordship, then straight away I'll take your lordship to para 10. The submission on behalf of the accused relying upon the decision of this court in Laxman that the day on which dying declaration is recorded, there was no extreme emergency or his condition was not so serious or there was any danger to his life. And therefore, there was no reason and cause this record the dying declaration. Therefore, the dying declaration is not believable, has no substance. In Laxman, which has been relied upon by the learned trial appearing before the accused, there is no absolute proposition of law laid down by the court that in a case when at a time when a dying declaration recorded, there was no emergency. Here in our case, although lordship dying declaration was not recorded, oral dying declaration is there, which was the deceased prior to date. Your lordship, it's a relevant piece of evidence. Although your lordship may not take it as a dying declaration, but it has come on evidence on record that he has mentioned two persons' name, that they have injured him, my lord. Then regarding my lord, one aspect whether 302 would lie, your lordship, in a case while the accused person, this is die out of septicemia, para 22, my lord, of the judgment. Prior to the para 21. Now the question whether the accused can be convicted for the offense punishable under section 302 with the aid of 149 is concerned. It is true that the prosecution has not established and proved who actually inflicted the knife blow. However, from the medical evidence on record and even from the deposition of the doctors, it is established and proved by the prosecution that this is sustained an injury by knife blow, which is inflicted by one of the 6 to 7 persons who participated in commission of the offense. From the dying declaration, it has been established and proved that the respondent accused Subhash Elias Pappu was part of the unlawful assembly who participated in the commission of the offense. Pappu, son of so-and-so, respondent herein was specifically named by the deceased in the dying declaration. Therefore, even if the role attributed to the respondent accused was that of hitting the deceased by hockey stick, in that case also, for the act of other persons who were part of the unlawful assembly or inflicting the knife blow, the respondent accused can be held guilty of having committed the murder of deceased Bengali with the aid of 149. Then para 22. Now the next question which is posed for consideration of this court is whether the respondent accused can be convicted for the offense punishable under section 302 read 149 IPC when the deceased died due to septicemia after a period of 30 days. Considering the decision of this court in Sanjay, the conviction of the respondent accused for the offense so and so, rated 149 is not warranted and the case may be found under 304 part 1. So I leave it to your lordship's discretion, although there are certain lordship lacuna, which according to your lordship, I leave it to your lordship whether it's a serious, it will go in the core of the prosecution case, my lord. I leave it to your lordship's discretion to decide that, my lord. But my respectful submissions is considering the materials available on record, your lordship will uphold the conviction. And one of the factor, my lord, these victim are from village area, your lordship, and your lordship, if considers the evidence given by the sons, they whatever the informant instructed, they followed, my lord. So your lordship will kindly consider the innocence, my lord. They on their own, they have taken back their father to their residence without giving any further treatment, my lord, on being instructed by the informant.
See, the factor
which has come is, forget the dates for the time being. What occasion took place on which date, we are omitting for the time being. Now, the father or the husband of the witnesses, they are attacked. They are taken to the Silchar Medical College. There they say, you take him back home, he's going to die. And this victim is brought back home. In the home, he is in a position to speak. And he did speak to he did tell the police what has happened to him. Now, even after that,
No treatment.
the FIR is not being
Not
lodged.
lodged.
And in the meantime, you see, on 19th, when the FIR is lodged, the police records the statement of this of the victim after the lodging of the FIR, and he doesn't. The assault is not, as per his statement, the assault is not that serious, and there is no. You see, the victim does not say say anything which should amount to, which will permit us to take that he was in a imminent
Danger.
danger of death.
Right.
That is not there. Does it not look unnatural? Doctors refuse treatment, saying that he can't be cured. Take him back, and in the house, nobody expresses. None of the statements of the witnesses expresses an apprehension of danger of his death, imminent death. That is not there.
That postmortem report, my lord, it
So
was
therefore-
gradual because it was inside the brain.
I understand, but so therefore the case has been developed after the man died. Then they have built up a case.
Maybe, my lordship, maybe. And one of the factor, your lordship, the incident had taken place in 2010. The evidence was taken in 2019, my lord. PW 1, 2, and 3, their evidence was taken in 2019. Evidence of PW 5 and 6 were taken in 2020, your lordship. So there might be inconsistencies, maybe there, here and there, your lordship, because of elapse of time. If it doesn't go into the core of the prosecution case, your lordship will kindly may ignore that part, ma'am.
Okay. So we close the matter then, Mr. Barbia.
Yes, well, just my lord, regarding this statement, my lord, of victim, my lord, already, my lord, in the referred judgment, there is, my lord, page, my lord, 31 in my lord, paper book judgments given, my lord, that, my lord, 31. Then my lord, relevant portion, my lord, page 34, my lord, just I am showing my lord the status of the my lord statement under section 161, my lord. 34, my lord, just my lord, after 4-5 lines, my lord, needless to stress, my lord.
30.
Page 34, my lord, I am directly just showing the relevant portion, my lord, 34. After my lord, 2, 4, 5 lines, my lord. Needless to stress, my lord.
Oh,
in my
judgment, compilation.
Yeah,
Okay, okay.
compilation. Page 34, my lord, running
Yes.
after 5 lines, my lord. Needless to stress that statements recorded under section 161 of the Code of Criminal Procedure shall not be used for any purpose except to contradict a witness in the manner prescribed in the proviso to section 162 1 and the first one, my lord, so and so, so and so. So, my lord, this statement, at least my lord statement, this is not my lord any evidentiary value. Another lordship kindly will look page 54. Page 54, my lord. Last, my lord, 5 lines, my lord.
Page.
Page 54, my lord, in my compilation. Last 5 lines, my lord. In her deposition, she has not stated anything that the appellant's original accused number 4225 were having the lattice, though she has stated in her statement under section 161 CRPC. The High Court has observed, relying upon her statement recorded under section 161 CRPC, that the appellants here in accused number 225 were having lattice. However, as per the settled proposition of law, statement recorded under section 161 CRPC in inadmissible in evidence and cannot be relied upon or used to convict the accused.
No, sure, I am not relying on 161 statement. Just
And my lord,
looking at the case where I found something, your lordship,
My lord,
just for 172 for aiding the trial, my lord.
And with all respect, my lord, my learned went, my lord, referred, my lord, to judgment, my lord, under section 141. This is, my lord, case of direct evidence, my lord, and there is a murder, my lord, and serious injury was inflicted, my lord. Perhaps in that case, my lord, motive was already proved, my lord. But here in this case, my lord, no eyewitness, no assault, nobody has seen, my lord. So, my lord, in this case, my lord, motive is not proved, my lord. My lord, in this case, actually, what happened, my lord, lastly, I am saying, my lord, actually, my lord, this man, my lord, as per my instruction, my lord, accused number 1 and 2, Hannan and his father, my lord, because of sound, my lord, planting of my lord, battle nut, my lord, there was some, my lord, simple marpit, my lord, on that day, my lord. But subsequently, my lord, after filing the case, my lord, these 2 persons, my lord, fled away, and my lord, still they are absconding, my lord, but subsequently they have come to their house, my lord. Therefore, my lord, in the first paragraph 7 of the judgment, your lordship may find, my lord, this accused number 1 and 2, against whom, my lord, this specific allegation is made, my lord, they are, my lord, absconding till today, my lord. And they are, my lord, they have not faced trial, my lord. And subsequently, my lord, this case, my lord, when, my lord, there is, my lord, some grudge or dispute, my lord, against the informant, my lord, and he made, my lord, all these allegations, my lord. And that about, my lord, I have, my lord, so far I have gone, my lord, all the, my lord, prosecution witness, otherwise also, my lord, materially, my lord, disputed, because, my lord, as per, my lord, evidence of PW1, my lord, my lord, son of, my lord, disease directly informed him, my lord, son of the deceased, my lord, informed him that, my lord, his father is tied up and, my lord, being beaten, my lord. But nobody has found, my lord, he is beaten, my lord, being beaten, my lord, or he is already tied up, my lord. He was normally found, my lord, lying injured, that like, my lord. But perhaps, my lord, another, my lord, is unbelievable, my lord. If anybody's father is being beaten, my lord, for some people, instead of, my lord, coming, my lord, for informing to anybody else, my lord, in a distant place, my lord, he should have, my lord,
How people
said,
react- How people react is not for us to.
yes, my lord, definitely one, but
That is not
natural,
there.
naturally, my lord, simply, my lord, instinct, natural instinct will say, my lord, that
You see,
definitely,
these things are subjective.
yes, subject, definitely, man,
And,
man to man, vary, my lord.
we can't put it in a straitjacket formula.
Yes,
You see, it may so happen that in my court, I have several support staff.
Mhm.
Let us say that in the house of one of the support staff, there is some emergency. And I'm here dictating an order.
Yeah.
In the courtroom. Maybe the court master will not be able to ask me that I want to go home.
Mhm.
It depends on the circumstances.
Mhm.
So you can't say that the staff attached to the court was afraid of the judge and therefore could not ask.
my lord.
It's not there.
This is subjective, my lord.
Everyone has a sense of responsibility. One may postpone his urgency because of the fact that in the court proceeding something is going
My
on.
lord.
So
Definitely.
it can't be said that in the house there was an emergency, therefore the staff
Definitely, my lord.
did not what you call, had no interest in his family members. It's
No.
not that. Circumstances, what circumstances compel a man to do, we don't know. No subject formula.
Yes. And another thing is, my lord, the PW2, my lord, in chief, my lord, she said, my lord, two boy informed, my lord. In the cross, she said, my lord, out of these two boy, one of them was, my lord, his her own, my lord, grandson. That about, my lord, my lord, deceased own nephew said, my lord, immediately after incident, my lord, he went there, my lord, and
That we have heard.
yes, my lord.
So that will not be difficult.
This is my humble subject.
Mr. E.M. Bhavia, who asked for the appellate. And Ms. B. Priyalandan, senior counsel and district people for the state. Briefed by the impugned judgment and order of sentence dated 6/5/2023 passed by the learned additional sessions judge Halakandi in sessions case number 147 of 2018. The present appeal has been filed under section 374 with regard to CRPC. Next one. By the impugned judgment, the appellants were convicted of committing offense under section 148 of the 447 of the 149 302 of the 149 IPC and sentenced to suffer simple imprisonment for a period of 6 months for committing of offense under section 148 IPC.
appellants were ordered to suffer. They were convicted and sentenced to suffer simple imprisonment for a period of 1 month. And moreover, for committing offense under section 447 of the 149 IPC, appellants were convicted and sentenced to suffer rigorous imprisonment for a period of 15 years and also to pay a fine of rupees 2,000 each default stipulation. Next. In brief format, the case of the prosecution is that on 15/10/2010, at about 11 a.m., the appellants herein, along with Mujibur, Mujibur, Rahman, and Hanan, Hannan, were forming an unlawful assembly, had entered into the farmhouse of the complainant and they had inflicted one cut injury on the hand and ear of the caretaker, namely Safiqur, Safiqur Rahman, and tried to kill him. It was positive that the matter was reported to the police at which police station?
First, my lord, the Pasgram outpost, my lord,
Panchgram outpost
then it was referred to my lord Algapur police station.
under Ardapur police station. And the victim was taken to Kalinagar, KALINAGA hospital for treatment.
and with the help of police, from where he was referred to Silchar Medical College and Hospital. On say later on 18/10/2010 at about 10 a.m. taking advantage of the illness of the victim, the appellants and other two accused entered into the farmhouse of the complainant broke open the door of the guard room, which was under lock and key, and took away betel, betel vine, VINE, betel vine, betel nut, bamboo tree, etc. thereupon. No, not betel, betel leaves, vine, these leaves, betel nuts and bamboos. Opened the locked door of the guard room, stole the articles and occupied the house. This is stated to be valued at around rupees 7,000 to 8,000. And the value of the betel nuts, betel leaves and bamboo was about 50,000 rupees. 50,000. The said FIR was received as Panchgram OP GD entry number 276 dated 19/10/2010 and forwarded to the officer in charge, Algapur Police Station, ALGAPUR Police Station, for registering a case. Accordingly, Algapur PS case number 250 of 2010 under section dated 19/10/2010 under section 147, 148, 149, 447, 448, 325, 326, 379, 380 IPC was registered. It appears that subsequently the Panchgram outpost, Panchgram police outpost, was upgraded to Panchgram police station, and the said case was re-registered as Panchgram PS case number 35 of 2012, dated 15/3/2012, under sections 148, 140, 147, 148, 149, 44. The earlier ones are there. Huh? The earlier ones are there. You add and 302 IPC. Next, it appears that after registration of the case, the victim had expired. So, out of the accused charged for the offences, two accused persons, namely Hannan Rahman, HANNAN Rahman, and Mujibur Rahman, MUJIBUR, could not be apprehended, and by an order dated 4/10/2018, the case against these two accused persons was filed. Insofar as the 6 appellants are concerned, on furnishing them with the copies as required under section 3207 CRPC. The learned Judicial Magistrate First Class, Hailakandi, by an order dated 14/11/2018, committed the case to trial before the court of learned Sessions Judge Hailakandi, and the trial was assigned Court of Learned Additional Sessions Judge Hailakandi. Charges under section civil important where IPC were claimed against all the appellants. Charges were read over and explained to them, and they pleaded not guilty and claimed to be tried. The prosecution examined 10 witnesses, namely page 111, and exhibited the following 7 documents, same page. However, the defense did not examine any witness. the course of trial, if, there are no next, there are no eyewitnesses to the incident of the deceased of the victim being assaulted. In his examination in chief, Abdul Razak Chaudhary, ABDUL, Razak RJAK Chaudhary, CHOU DHUL, with a bracket PW1, has stated that he was informed on 15/10/2010 at about 11 a.m. by the son of the victim that the appellants herein had came in a group armed with deadly weapons and by trespassing into his farmhouse, assaulted the victim, as a result of which he sustained cut injuries on one hand and one ear. He rushed to the place of occurrence and found the victim lying on the ground in an injured condition with profuse bleeding. He had informed the incident to the Panjgram police station. Through the police, the victim was treated at Sarojini, SAROJINI, Block Public Health Center, Alinagar, from where he was referred to Silchar Medical College and Hospital for just a minute, SMCH, for treatment. However, the victim had died because of his injuries on 19/10/2010. And thereafter, the appellants again trespassed into his farmhouse and took away betel nuts, betel leaves, and bamboo. And thereafter entered into the house of the deceased by breaking the locked door, trespassed into the said room and looted all the articles. First one. In his cross-examination, the PW1 had stated that he had not explained the reasons for 5-day delay in lodging of the FIR, and stated that he was busy in providing treatment to the deceased and to the victim. He denied the suggestion that that no treatment was provided to the victim at Kalinagar PHC as well as SMCH Silchar. And he also denied that the victim did not die due to assault on him by the appellants. Next part, Flatul Begum Chaudhary, ELFA TUN. Begum Chaudhary, CHOUDHY, was the wife of the victim, was examined as PW2. And she had stated that on the day of occurrence, which was Friday at about 11 a.m., her husband was in duty in the house of the informant as a chowkidar, and she was in her house, which is 3 which are intervened, INTER, by 3 numbers of TILLA, TILLA, within bracket hillock. And at that time, 2 small boys came to her home and informed her that the appellants were assaulting her husband. And on reaching the nearest TILLA of the place of occurrence, she saw the appellants coming back from the house of the within bracket PW1. And they were armed with lathi, dao, etc. And when she was rushing to the place of occurrence, the 2 of the appellants, named FATAR and Malik, MALIK, had assaulted her with a lathi. And on reaching the place of occurrence, she saw her husband lying on the ground with injuries and in an unconscious state with profuse bleeding. She has said that thereafter the police came and took her husband to Kalinagar Hospital and then to SMCH Silchar. the doctors of SMCH, Stretcher, told them to take her husband back to home. As he had no scope of recovery. And after 4 days of the incident, her husband had died. And thereafter, the police brought the dead body for postmortem, and this was conducted. We have to break up because there is a single bench of
Yes. Lordship,
We are reserving the judgment.
my lord.
Just aim for the- Anything else in the house plan? Items are completed, judgment is served.
Well,